Lordship's permission, may I mention a contempt petition in this genetically modified foods case, which was filed actually more than a year ago. Unfortunately, it's not come up for hearing. There was an order passed by Justice Nagratna's bench, which said that the government can only bring out GM foods after they have laid down a policy. But without that, my lord, there are a number of genetically modified foods which are being allowed in the name of some newer technology, etc. So we had filed that contempt petition. We just want a listing. Unfortunately, my lord, despite efforts, it has not been listed so far.
Well, I am craving my lord's indulgence to mention.
This is a matter, my lords, which is only in writ petition, my lords. This has not seen a light of the day since September 2025, despite being in specific order in this regard. This matter, my lords, was last listed on 22nd of September 2025. And there was a direction for the matter to be listed, my lords. I'm only requesting that my lords may kindly...
All of those who wanting expedited hearing, please give your note, we'll examine it.
My lords, I have already prepared that, my lords.
Well, I'll give the note, Wallace. We'll give the note.
Only
Bangalore Municipal Corporation, which my lord, the Honorable Chief Justice Bench has heard many times, IA is already showing on the list for Wednesday. It should not be deleted because the Lordship's deadline is in June, when Lordship will not be sitting. There is an IA by me. Yes, my learned friends got some obliged. Same matter.
Sorry, my lords, I could not complete. In my matter, there is no specific date, and that is the reason why it's not listed.
So that in the
Yes.
most of the matter, there might not be a date. But
Yes.
this is the note we will examine.
Yes, my lords. Yeah, I have.
May I mention a matter, my lords, arising from the Bombay High Court. My lords, 31 different proceedings in the Bombay High Court have now been clubbed together with respect to the Leelavati Hospital. And my lords, the court has said that we are going to supersede the board.
In their own way. So
No, that's right. I'm only asking for an urgent listing of that because the High Court has now said that we are going to supersede the management. So, my lords, that is where the problem lies. So, it got. No, my lords, I'm only asking for an urgent listing of my SLP. That's all.
My lords,
Your lordships, my lords, consider this. There was some urgency in this.
No promise, no denial. If the note, we will examine. That's all.
We only drive on hope. So, my lords, the hope is there. My lords, so if your lordships would.
Seek my lords leave to mention item 115 listed before my lords today. This is
115.
the anomaly matter where your lordships had indicated a bench of two cannot consider it. Our problem, my lords, is that there is a lease which was granted to us in the previous FSI report, and your lordships have granted a status quo. We only want a clarification.
We will not hear that matter in piecemeal. And I will not allow any, we are very clear, me and my brother, and it was three-judge bench matter. We will not permit any activity unless we are fully satisfied.
We're not asking for activity. We only want the status quo to be maintained because I bought an auction lease based on the FSI report.
Status quo is that you will not operate. Status quo is that you will not operate. That's all.
No, status quo is in relation to a lease I have not yet obtained because it will expire by a flux of time. And it is in
whatever has expired has expired. There are a lot of things happening there.
No,
we are getting the kind of feedback. It's quite disturbing for us.
I have not been able to explain myself, my lord. This is an LOI, a letter of intent, which was granted based on the original definition of Aravali's in the 2010 FSI. Now, my lords, the state gave a certification to that. I, in fact, applied, succeeded in the auction, paid installments in that. All that I'm asking is, because under the my lords, MMDR Act, it will not go beyond a certain period.
If they cancel your lease, I think that's an independent cause of action. You will tell him, we will examine it.
No, I'm saying only this, my lords. LOI, letter of intent, lease not yet granted. We only want that while your lordships are considering it, let the status quo obtain. That's all we're asking.
We will not pass any order in favor of the lease holder, the mining holder. The entire problem is created by this. We don't want to use the harsh word, but it is all because of these mining.
No, my lords, I'm not saying anything. Could your lordships just distinguish?
These are very sensitive ecological issues there. We have already requested one or two, at least domain expert lawyers who are assisting us in the matter, but we still know we are not experts. They are also not
We are
the
only asking that.
kind of experts they need to examine.
We are only asking.
Last date, we recollect, we have already asked all of you, all parties to give us the names of the eminent experts who can work independently and submit the report. Then we will see what can be allowed and what cannot be allowed.
Just list it before the petition so that we can bring the issue to your, my lord's notice.
We
Your
will,
lordships just.
meanwhile, we will examine that. If you have any issue, please file something and then we will consider.
It's listed today. It's listed today.
Please now allow us to take up the today's matter.
Just one last request, my lord. I have a fresh matter, my lord, where, my lord,
All of you can give your, we have said, give the
Manoj?
papers, we will examine.
my lord, mine is a fresh matter, that's the difficulty, my lord. Would your lordships? What is going on? This is.
My lords,
We can't, at least I won't be able to hear like
The
this.
difficulty is when we go in a sequence, my lord, everybody jumps the sequence here, my lord. It's very,
There is no sequence.
the rest of us get left out, my lord. That's what we feel, my lord.
That's one thing. Are we not strictly following? If the registry is not following, because then you have to tell me. Is the registry not following that the moment you cure the defect, within 2 days matter is to be listed?
The lordships are right,
That
my lord.
rule is being implemented.
My lord, the
Now
difficult.
you can only, you are required to make mention of only those matter which you think that you will, can't
My
wait
lord, that's
for 2
why,
days.
that's why the only trouble is this is a fresh matter, order which is.
Those matters which can't wait for 2 days, please make out the reason mentioned in the piece of paper.
Very well.
Oral mentioning, I am not going to.
Very well, my lord. We'll
have
give
to
it.
conduct-
Lordships. We'll give the reasons.
Meeting,
Absolutely.
we'll examine.
We are grateful, my lord. We are grateful.
I have to give in a mentioning my matter. They are not.
Now look at, you are speaking, madam is speaking. What kind
Our
of-
apologies for that, my lord. Our apologies.
Person I am appearing before my lord. I have mentioned to them 13 and 14 for mentioning it, but they are not mentioning. There is an urgency, my lord. MCD may come and demolish my flat. That is the reason there is urgency in the matter, my lord. Yesterday, even 6 o'clock, I met the. Because the
When did you file that application?
petition, no, SLP, my lord. SLP I have filed.
In the application, you have filed some IA?
No, I have not filed an application for stay of the execution.
You have filed today morning 10 AM.
Now, no, my lord. I have given yesterday and even.
No,
I
you have filed today. It is being listed.
13 also 13.
Have patience, matter is being listed, madam. We have already fixed a date in your matter.
Date I have not in.
You said, do you want us to hold court now on Saturday, Sunday? Then please wait for a working day.
My lord, allow me to mention.
Now, all those mentioning where you were, we want to your matter to be dismissed, that's all. Please give us, where? Rest of the judges, former judges are there. You think I am going to interfere in that? Justice Ranjit Singh Randhawa, Justice Jayashree Thakur, Justice Nirmaljeet Kaur, they have conducted elections and you want us to interfere?
My lord,
No,
allow me to mention.
Don't.
Bar Association.
Bar Association, we can't do anything.
The order passed by this honorable court.
You are the leaders of the bar, you should people go there and agitate. Today I will not speak about your bar. The day I will speak, then I will speak too much.
My lords, may allow me to mention. My lord, is a service matter.
Better I don't say anything.
My lords, I may mention.
So what can we do, madam? We can't stay you.
Assured us that, in fact.
If the elections are held and our directions are not followed, do you think they are above law? I am having a close watch of day-to-day happening. Do you think I am sitting here in ivory tower? And not only in your high court, all the high courts. I am watching
My
everything.
lords, may allow me to
That
mention.
means
My
they
lords, it's a
present
service
themselves.
matter. My lords, it's a
No,
service
nothing to be
matter.
stated.
Lordship's
I
permission.
will not say.
With
My
your
lord-
Lordship's permission, this is a demolition matter, my lords. Demolition is scheduled tomorrow, my lords.
Bhaiya, let it be demolished at a time.
My lords,
You want them-
my lords, I have a genuine difficulty. I would not mention if it were
Thank you
not.
very much. Now please allow us to work.
My lords, may I?
My lord, may I allow just one mention? My lord, it's a service matter. He's out of service for 8 years, and my lords, his superannuation is he'll attain superannuation.
What is the urgency?
My lords, the superannuation is in August.
Superannuation, it's all right.
My lords,
With your kind permission, I'm mentioning it.
The anomaly matter was, since it's from bench of 3 honorable judges, kindly fix it for 3 honorable judges.
We will do that only when you will allow us to take up the case.
Because there are certain, application of which-
Whatever urgency there, we don't care about that, but we will list it before a free judgment, then we will hear and see what is going.
My lords, I have
Final hearing.
But unless it pass the preliminary musters of expert committee, and I think we are not going to touch it.
my lords, I have a genuine difficulty.
We will not allow an inch of land to be utilized for anything.
My lord, what is the matter? If my lords will just give me one, I'm very sorry. I've never done a oral mentioning like this, my lords. But there's a deforestation happening in Sasoli village in Sindhudurg. Now, my lords we've mentioned it. My lords has in fact passed directions. But what is happening is because of the large exercise in T.N. Godavarman, the IA, despite my lords' directions, it's not getting listed. Now, my lords, I had one request. Either my lords, if my lords would list this IA, but I understand that may not be possible because one IA can't be singled out like this. The amicus has indicated that we should actually go to the High Court.
No, your IAs are in Godavarman or?
They're in Godavarman. It was before the cutoff.
Have you seen that order in
Yes, my
Godavarman?
lords, I have. In fact,
Then
that,
one option you have to withdraw the IA.
yes, my lords. So only for that reason, my lords, can it be on Monday? We want to withdraw just so that the High Court doesn't feel we tried to.
So who wants to withdraw and who don't?
Yes, my
Those
lord.
who
I
want to withdraw, they can file a withdrawal application.
But my lords, the difficulty is the High Court will say you tried to circumvent because Supreme.
We'll see, we'll try to list it.
My lords, my
List करो भाई detail सिर्फ list में adding दे दो. Those who want to withdraw the IA and go to alternative.
Yes, my lord.
My lords, my case was listed on 26/11 for final hearing. My lord, it has not been taken up.
Date. So don't go.
Where is she? What is the date in the ISO?
26.
For petition which was registered by the registry,
Second of?
my lord.
25th.
But now they say it is not maintained.
Which is mine.
Not listed
It's mine.
before the court. My lord, it's a trademark matter. My suit is filed in Meerut District Court because of the pecuniary jurisdiction being unlimited. The opposite side has filed the same infringement of same trademark in the Bombay High Court. Waive the Bombay High Court. I want
Not concerned of the other.
the case to be transferred from Bombay to District Court Meerut. Court says that there is no, the registry says there is no power to transfer from High Court to District Court. We will not list your transfer petition. I told them, let the Honorable Court take the call. Let the transfer petition.
We will see, we will. Madam, this is what we are requesting. We will examine everything. Yes, item 15 and 18.
Please, my lord, I appear in this. Now, my lord, this is being pending for a long time. We,
Lord, appeal is listed on 25th. I am ready with the matter, my lords.
my lord, appeal is listed. They keep filing applications after applications. All the applications have just got disposed in the last day. It is fixed.
Fixed on 25th, my lords. Otherwise, there are
fixed
three
on-
neat questions of law. I am ready.
Decide, but let the appeal finally be heard out.
My lord, I am not coming in the way of the appeal being decided. But then, after all, this application in relation to bail, which was granted by the court,
Mr. Aryan,
which has been stayed,
Mr. Aryan, one way can be that without any referring to any detail, we set aside the order and request the High Court to pass a fresh order.
no, no, my lord, I essentially am, and there are issues which I need to address your lordship on. Because here is a situation, there are two basic issues, my lord. One, I have been taken into custody, one on the premise that I am a public servant. That aspect your lordship will look into. The second element is that the child is a minor. The prosecutress was a minor. I am in a position to show that she was not a minor. On both counts, I don't know why I am in custody.
Lord, I'll answer that question first.
There is a finding from none less than the Board of Aims that she was more than 18 years of age at the time when the incident happened. There are 6 opinions, medical opinions in the favor of the person.
Request the High
The-
Court to look into all these aspects and pass a fresh order. We can also request the High Court that before the summer break, the appropriate orders may be passed.
On the bail application, my lord? Very good.
Lord, may
On the
I say
suspect-
only one thing? Lord, the entire order, impugn order proceeds on the ground whether it applies section 3(4) or 5(6). Lord, I will go into, if required, my lord, in the controversy about the age, etc. But the main conviction is under section 376(1) for remainder of the life. Lord, the High Court has, Lord, not taken into consideration that
That
and
is what we
say,
are, Mr. Solicitor, that is what precisely we are noticing. That even according to you, some aspects of the issue could not be taken notice by the High Court, while considering the prayer was limited only for suspension of sentence.
yes.
Let us also keep that margin in mind. High Court was not hearing the appeal. Maybe at the time of hearing appeal, the issues are enlarged and then detailed arguments are taken. Probably both sides went on the premise that only a suspension application is being heard. But you are right, there are issues which requires maybe judicial.
One Lord, important issue which may require adjudication is whether MLA is a public servant for the purpose of POXO Act.
Exactly.
In Antule's case, the limited point was
that hyper-technical approach High Court has taken, we do not endorse.
yes.
No, my lord, I will essentially, my lord, convince you on that.
Whether sanction is
Your lordship
required.
needs to hear me.
We understand that you are taking advantage of.
I am not taking advantage, my lord.
Or in the POXO Act saying that any definition.
That is why I start, your lordship, I started,
But this is a legislation which is not only a penal legislation, it is a legislation which protects women, children from sexual exploitation and
when
other
the,
forms of grievous crime.
my lord, it is, my answer to that.
Position of dominance, that is the test.
There's two difference, right? Section 21 of the old penal code and the definition of public servant under the Prevention of Corruption.
Unless context otherwise requires.
See Prevention of Corruption Act,
My lord,
MLA goes into public servant basket.
Not the trial
Now,
court, only a minute.
Can I get an
the
answer
trial
on that?
court records the finding
Mr.
that
Alias.
MLA is in a dominant position
Mr. Solicitor.
under
My lord.
section 5.
Solicitor, Mr.
My lord, this is,
Just listen. You see, let us also have always practical aspect in mind. There is an order passed by the High Court suspending the sentence, right?
after, my lord, 10 years of custody.
So, right, in your favor, we are saying so. That order is stayed by us. Now there is a suspense. The order is illegal, the order is erroneous, the order is correct, the order is partially correct, the order is partially incorrect. When this state of mind is there, High Court probably will be reluctant even to take up the main appeal because some of the issues sometimes while touching, because when you need to pass a speaking order in suspension of sentence, you unwittingly touch the merits also. And when you touch the merits, then you know that if the appeal is taken on merits, those issues will again arise. So what will happen? The High Court will be waiting for us to now opinion. Our predicament is that at the stage of suspension of sentence, if we express any opinion, unfortunately for that issue, one of you will lose the first place.
Closed. The option will be closed. If your lordship expresses a view on that, the option will be closed as far as either I am concerned or the other side is concerned. I am conscious of that.
So
that is why, my lord.
One of you will lose one platform. For that purpose, we were only saying that we, without any saying that order is erroneous, illegal, or not erroneous, we set aside the order, send the case back to the High Court with two options. One, that either you decide the appeal itself, or if you feel that the appeal is likely to take some time, please pass an appropriate order on the application for suspension of sentence after hearing all of it.
And
Lord,
without
now what
being
happens
influenced by the
now can I just
order under challenge, my lord. Without being influenced by the order.
Of course, once we set aside that.
Your lordship, sir.
Your lordship, once the order gets set aside, in a way, it is a kind of a reflection of an opinion of the superior court to the High Court.
All right, we are offering you the order which we want to pass. Right on.
My lord, one more thing.
Just a minute. We are only giving you a draft order. We are not passing the final order. We are only.
Anything that falls from your lordship's mouth.
Just one thing I wish to similar, there are additional grounds.
Just a minute, please. During the course of hearing, it transpires from the rival submissions that in addition to the issues which have been prima facie touched by the High Court while passing the impugned order re-suspension of sentence, there are several other issues which too require to be looked into even at the stage of passing an order on suspension of sentence. Also, keeping this in mind, and without expressing any opinion on merits on merits of the prayer for suspension of sentence, comma, we allow this appeal in part, set aside the impugned order, and remit the case to the High Court with the following requests. One, the High Court may make an endeavor to decide the main appeal as early as possible.
My lord, there are 5 occasions where I have already argued this appeal completely. My lord, why am I being put to fault on this aspect?
See the order first, then you will decide.
I don't know what more I can do.
Finally, as early as possible and preferably within 3 months, more so when it is us before us that the appeal has been on the earlier occasions argued at length. 2I, in case the High Court finds that the appeal is not likely to be decided early, it may pass a fresh order, re-suspension of sentence on the prayer for suspension of sentence, after hearing the parties, including the counsel for the victim complainant. Also, in this regard, it is clarified that while setting aside the previous order, we have not expressed any opinion on merits of the prayer for suspension of sentence also.
Well, only one request I would.
Will not be governed by
Only one request.
Can it be subsumed?
Or the prayer for suspension of sentence shall be influenced by the observations made in the order.
Only one request I'll make. Your lordships initially were pleased to write that there are some additional grounds which are not considered. My lord, the grounds considered also, my lord, needs to be revisited. For example, whether he is a public servant. So kindly clarify, including grounds which are considered, maybe requires reconsider.
No, I am.
Because
It can be
there is a
done in a very
finding
simple
that
fashion. Let the
Upon which the High Court has made certain, has given a prima facie opinion.
I have a suggestion based on what my learned friend is saying. Let the suspension application be heard afresh and all grounds be considered.
Yes.
That's all.
He's saying that let the application proceed.
Without prejudice to either side.
But that is exactly what is done.
That is what is being.
If you want, we can limit that also.
That's all I am saying.
But my lord, I'm sorry, my lord. I'm sorry, my lord, your lordships may have to say something about the findings recorded.
That is what we have observed.
Exactly.
That the fresh hearing will not be hindered by the observations in the order that we are setting aside. So that.
My lord, I have much to say on that. My friend may say something. I have also much to say.
I am ready to assist
your lordship may decide otherwise against me. But hear me.
You have very compelling textual arguments to make. We are conscious of it.
We are not textual alone.
I am ready to lose on that ground before your lordships. If he wants, my lord, we can argue here also.
We don't want to make any observation.
That's entirely your lordship's
the date of the final appeal.
The order may be, appropriate order may be passed, preferably before the commencement of the summer vacations.
Your lordship gave some systems.
Orders may be passed, preferably before commencement of summer vacations.
In the suspension.
Application for suspension of sentence. Now, may appeal part we have deleted.
Very well.
Right.
I am grateful.
Oblate.
Gratefully.
The order.
Yes, it's
Order is set aside.
Exactly.
On all points. Cannot be argued.
The order is set aside on all the points.
Oblate.
But not everything to be heard afresh. Because now they are going to use that the order has got set aside, so it is a kind of res judicata against me.
No, we see, otherwise we can't pass contradiction.
All the findings.
I am trying to say that what will be used by the other side against me.
No,
A fresh order will be passed. So that is the idea. That
My lord, 15.1 is not maintainable. It is in the nature of a PIL. That should be dismissed. 15.1 and 18.
What is it?
15.1 and 18.
I'm
So that is what the ED officer says. So still there will be a balance of about 500 crores. It is not connected with this matter. It's not a predicate offense.
The state has to do.
It is not connected with this. It's not a predicate offense in my case, this particular FIR.
We just wanted to know the extent of exposure and the amount which ED has.
Extent of exposure that way is
3,700 crore, you say.
No, 37,000 crore was there.
No, Milas.
that my instructions, even my PC says 3,700.
Milas, it is 3,700 crore. It is 3,700.
3,700. State will be called on, but ED is not concerned. According to our
It has no information. That is why we required the ED to be
And Milas, in fact,
notified.
the prosecution complaint says, Milas, 420 CR was deposited with the tax authorities also out of this, Milas.
We
The
do not know
prosecution
how
complaint
much
says-
is returned to the investors.
Yes, 2,600 is almost returned to the investors also, Milas, out of this.
My note is very clear, Milad. My note is. Para 3 says 3,700 crores approximately, Milad.
And what about her husband? He is in custody or he is on?
Yes, Milas, he is custody.
This,
Milas.
this case, I'm
He's
not
in custody,
connected in
Milas.
this case, Milad. I'm not connected with this case. My predicate offense is different. This is not the predicate offense as far as it is concerned. This is another offense as far as they are concerned. There are large number of investors who have been duped. This is one more case. This is not a PML offense. This is not a predicate offense in which we have filed two separate cases. Those pieces are not connected with this FIR.
No, the point is that we are considering her prayer for bail.
Yes, Milas.
So you have no objection.
We are not concerned, Milad.
Who is the state of Rajasthan?
State of Rajasthan. There are only 12 cases in Rajasthan. Majority are in state of more than 200 FIRs in state. Plenty in Haryana and NCT of Delhi also.
Milas,
That we know that they are not only national players, they are international players. But the point is that how long you keep.
And this is the wife, wife of the principal.
He was
Milas, they are in custody for Milas, 8 years in the custody, Milas. 8 year plus is the custody, Milas, since 2017. All attachments were done in 2017, Milas.
Happens to be
But may I leave, Milad? I'm grateful.
wife of the main accused. Their companies are said to have duped investors to the tune of 3,700 crores. In bracket wrongly mentioned as 37,000 crores in our order dated 23rd March 2026. As per the petitioner and her associates are arraigned as accused in 257 similar cases. She is said to have been granted bail in 254 cases. Next paragraph. The instant petition pertains to the petitioner's prayer for bail in FIR number 18/2018, registered at Police Station Naya Shahar, Bikaner, under section 420, 406 and 120 capital B IPC. आपने लिखा था ना, their company Messrs Ablaze Info Solutions Private Limited. Next paragraph. The petitioner was first time arrested on 26 December 2017 by Uttar Pradesh Police in FIR number 259/2017, registered at Police Station Kavinagar in UP. The instant FIR number 18/2018 was registered on 10th January 2018. The FIR reveals a digital marketing-based scam in which the company AISPL offered paid online tasks like sharing advertisements in return for promised earnings. Users were required to purchase IDs stroke packages by paying upfront money with assurances of regular returns. So this is how hundreds of investors on pan-India basis have been duped. As for though gravity of the offense and its financial ramifications coupled with the fact that there are hundreds of victims of the country, we would have declined bail but for the following mitigating circumstances. One, the petitioner is a woman and was inducted as director after her marriage. The main kingpin appears to be her husband, who is also in custody. Two, substantial assets approximate more than 650 crores have already been attached by Enforcement Directorate.
Yes, Milos.
In addition to these are assets or cash of 130 crore by state.
As well as UPSTF also, Milos. UPSTF was also attached 130 crores.
UPSTF,
UP Special Task Force, who initiated the investigation, 130 crores.
These are assets or?
Yes, Milos, movable, immovable, both. The bank balances and properties.
UP State, UPSTF. Difference to both are maybe.
And Milos, one more summation, Milos, 420 crores out of this 3,700, 420 crores admittedly in the ED has said deposit with the tax departments. But we filed with the tax department on due time, service tax and TDS.
Have you, how much have you returned?
Milos, 2,600 crores.
The petitioner.
This is the approximate figure.
It is further claimed that the company in default has already refunded over 2,600 crores.
Yes, Milos.
To the investors. This is an unverified fact, and hence no reliance can be placed. Next paragraph. Be that as it may, the petitioner is in custody since the year 2017. There being multiple cases in different parts of the country, from a conclusion of trial will take time. Taking into consideration all the attending circumstances, the instant petition is allowed and the petition is directed to be released on bail, subject to a furnishing bail bond to satisfaction of the Chief Judicial Magistrate at Bikaner. Next paragraph. It is our directive that no court shall defreeze the assets attached by the ED or STF or any other state agencies till all the trials are concluded. So similarly, the ED, state police or any other investigating agency shall be entitled to attach the left out movable assets of the petitioner, her family, close relatives, or all those associates who are suspected to have been the beneficiary of the defrauded money. None of such assets shall be released by any judicial stroke quasi-judicial body without the leave of this court.
Yes, because I have just
Without the leave of this court. Next paragraph. The Chief Judicial Magistrate shall impose such other conditions which will ensure that the case appears before the different courts and does not evade the process of law.
Because I have just one more submission, since Melos have directed that no other court will defreeze it, Melos. Melos, in PMLA court, under Section 8, Subclause 8, ED has a power to release those assets after verification to the due
We
claimant.
will not permit that. That's why the order, quasi-judicial board or court, PMLA court.
Please,
Please this order.
please. I'm to oblige.
Unless it is for the benefit of the victim.
Yes, Melos, then that's why something.
Unless it is to the victims
To the
itself.
victim, Melos. Melos, my submission is that only.
After due verification.
They see leave of the court.
Yes, fair enough.
Melos, it's for the
It's
ED.
for the benefit of the
And they'll
investor.
siphon it off. That has also happened, my lord, in many cases.
Melos, if ED does that, we will not file any application, Melos. I was making that submission only.
Deeply obliged.
Oblige, Melos.
Next paragraph. This order shall not be treated as a parity for the purpose of considering the bail, prayer for bail by the petitioner's husband or any other accused.
Deeply obliged.
I'm obliged.
Lots. 17. Please, Millers. These are bail application.
13 corrected matters, Millers. I made a small chart for my lord's convenience. Yes, 13 corrected matters.
Accused have been granted bail by us.
And my lords have granted bail to one of the co-accused, two of the co-accused persons.
Three co-accused have been granted bail. Please, Millers.
Saifali, Roshan Thakur.
Please, Millers.
And who is the third?
Millers, Divya Chandravanshi, that was granted on
Millers,
16th
it's
of
at
February
page
2020.
36 of the SLP, Millers. The order where my lords have granted bail.
Millers, after the SLP was filed, one more co-accused was granted bail. We are carrying those orders. If Millers require, we'll just file them.
What are the allegations?
Millers, gambling, punishable up to 7 years, Millers. They were running illegal betting apps on cricket, Millers.
Millers, 13 months in jail.
IPL and Millers, the seizure, they have been 10 mobile phones, 7 mobile phones have been seized for one of the accused persons. Millers, they are rating this. At least, Millers.
It is not in dispute that the petitioners co-accused, in bracket Roshan Kumar Thakur and Saif Ali.
Saif Ali and Chandravanshi.
Saif Ali and
Divya Chandravanshi.
Divya Chandravanshi.
So and so have been granted bail by this court. Wide orders dated so and so. Give us the three orders separately. Wide order dated so and so, passed in so and so, so and so. For the reason assigned in those orders and without expressing any opinion on matter. From the instant petition allowed, the petitions are directed to be relieved on bail on same terms and conditions.
Millers, just one thing, Millers. Most of these accused persons, Millers, are from different states. So they should appear before trial court on each of the Millers because.
Of course, they will. The petitions shall continue, shall regularly appear before the trial court. And in the event of absence, and in case he absents, it shall be taken as misuse of concession of bail. Yes, anything, what is Prashant Agarwal?
This is
Next matter.
Next matter.
Next matter.
Item 20.
Well, it's in item 20. I have instructions to withdraw the petition, my lords.
Withdraw.
Prashant Agrawal.
Withdraw.
I have instructions to withdraw the petition. Just a small request. A small request, my lords. I may be permitted to pursue the matter at administrative side, my lords. With liberty.
You have made your representation against the.
Yes, my lords.
On paper, the petition states that representation has been made to the competent
Yes.
authority. The instant petition is accordingly dismissed with liberty to the petition to pursue that.
Obligements. Thank you.
21, Millers, the interviews are currently underway. The process is on. Millers.
Lord, I'm petitioner in person, my lord. Lord, this is third time, Lord, I have been forced to approach this honorable court, my lord. There have been clear directions to show the compliance expeditiously, my lord. Now, my lord, it is very unfortunate they don't understand the.
You have no, entire world may be eligible to become senior. At least you are not entitled.
Yes, absolutely.
If the High Court makes you senior, we will set aside that one. This is your professional conduct.
There is no other litigation, sir.
Extremely sorry for that, my lord.
You have no other litigation apart from assuring your senior advocate
Very
status?
unfortunate.
The High Court, if designated by mistake, we will set aside that.
This is the standing of a person you expect to be conferred a senior
Start
advocate.
filing contempt, you filing.
Lord, your lordship had passed the order promptly, my lord.
Correct.
So what?
The petitioner indulged in filing frivolous petitions.
Let this be
He
taken
appears to
into
be
consideration.
I'm extremely sorry for that, my lord.
Who does not
This be
deserve,
taken
who
into
does not deserve
consideration
any
while
consideration
considering
for
his
designation as senior advocate, the petition is dismissed.
Lord, I'm extremely sorry, my lord. I'm good on merits, my lord. That's why I'm approaching, my lord. Please forgive me, my lord.
So this shows, sir, with deepest humility and respect to you,
I agree, my lord.
it shows that you are not fit to be considered for a senior advocate.
If by mistake that is
This
given
is,
to
if
you,
this
how
is
you
the
are
lack
going
of patience you
to behave
have,
like a bull, that can
and
be
you have
understood.
no other litigation.
Lord,
Just to pursue your senior, is senior advocate a status to be ornamentally kept at residence? Or a recognition for your role and participation in the justice delivery system? This is your role in the justice delivery system, to assure a senior advocate down to yourself.
Lord, I have worked bona fide.
This should be taken into consideration by the committee.
So that's why, Lord.
Yeah, in rally mein to I'm waiting for some matter. Why don't you file some case? I want to give to CBI to verify their LLB degrees. Most of the Delhi, the kind of in Tis Zari, so and so 3-4 courts, the kind of Facebook and all these things they are putting. Do you think we are not watching? And we need to have this. BCI will never do because they are in collision. They need their votes.
Lord, all the
And thousands of them are all fraudulent people who are wearing these black robes. I have serious doubt on their genuineness of their degree.
I withdraw, my
Only
lord.
probably CBI need to do this something.
I withdraw, my lord, and
BCI will never do because they are absolutely in collision.
I withdraw, my lord, and I'm extremely sorry for that, my lord. I withdraw, my lord.
This may be done to be.
May I request your lordship to remove the remarks, my lord. I'm extremely sorry for that, my lord.
कर दिया कर दिया
मैटर था वो कहाँ गया वो क्यों नहीं लगा रखे उसको
In fact, your lordships had taken notice a couple of weeks
I
ago.
want to read that what kind of language he is using on the Facebook.
Your lordships are right.
Let people understand, and he thinks I will going to teach them what is the meaning of the discipline in profession. I have dealt with so many this kind of characters in past.
Lord, I have laurels, my lord, in this profession. I'm extremely sorry if I have hurt you, my lord. So I request to remove the remarks, my lord.
You people will not have any respect. Oh, you expect the outsider.
No, my lord, I understand. I understand.
There are already parasites in society who attack you people, you attack the system, and you want to join hands with them.
No, my lord. I understand, my lord, and I am.
Have you seen there are youngsters like cockroaches, they don't get any employment, they don't have any place in profession. Some of them become media, some of them become social media, some of them become RTI activists, some of them become another activist, and they start attacking everyone. And you people file contempt petition because High Court is not taking up the matter of as if they.
Lord, I have been very serious in this profession. Lord, today even 5 matters are listed before this honorable court. Lord, besides this.
Pursue that.
So I understand, Lord.
That is your recognition.
I understand the inconvenience caused to you, Lord.
Is it in a senior advocate's status is something which is conferred on you, not pursued by you? You are pursuing it. Does it look proper for your standing and respect that should be conferred? That you pursue to the end of the world to get a senior advocate's status?
May I request your lordship to remove the remarks, my lord. I bow down, my lord. And I withdraw.
Withdraw. Item 22.
Grateful, my lord.
Item 22 is here. Lordship, my matter is particularly about the village common land, which is particularly related to the Dholi.
I mean, nothing can be done. We election process.
Yes, sir.
Election means nothing can be done at this stage. We'll see for the next election. We have already issued direction. In view of the fact that the election process is now near complete, No effective directions can be issued at this stage.
क्या सबके लिए?
Yes, item 24.
This case is concerning the grant of pensionary benefits to short service commissioned officers of the Indian.
How this MA is maintainable, sir?
My lords, the judgment of 24th March of 2020.
MA, BA, PhD सब इसी में file कर देते हो. How MA is maintainable?
My lords, may kindly come to page 48, my lords. Para 30.
How MA is maintainable, sir? This is the question we are asking. Did you go to AFT? Answer is no. Did you go to High Court? Answer is no. Did you challenge the order of your discharge of 2023? No. Did you go to any forum? No. Now some judgment be delivered, you say give the benefit of that.
Well, other persons, other personnel have gone to the Delhi.
Go and then approach the appropriate forum.
Well, just one moment. The other personnel who have gone to the Delhi High Court, they are asking for the grant of benefits over and above what this court has granted.
Solely misconceived, being not maintainable, dismissed. How the petition applicant shall be at liberty to avail the remedy in accordance with law.
Malus, may kindly grant me liberty to approach.
25.
Please, Milords. Milord, the short issue is this, that the provisions of Lokayukt Act mandates under 23 that hearing precedes decision, Milords. And in this case, and Lordship.
In those other matters.
Lord, that matter Lordship has issued, Lordship may I just pass on the order.
Know that we have committed a mistake, but for which date?
Lords, the website is not showing any date in that, Milord. Lord's last order is of 13th of March 2026, Milord. And Lords, the same issue is covered within SLP number 888 of 2026, Milord.
ये सारे मैटर ना उसमें जो लास्ट वीक है ना मिसलेनियस वीक उसमें लगा दो कोई डेट उसी के साथ लिख दो लिस्ट शो मेन केस ऑन सो एंड सो डेट और उसको साथ में टैग दिस केस विद दैट.
Because in the meantime the
operation nothing meantime we will decide in after 10 days we will decide the main case.
Please, Milord.
21 जुलाई ये इसमें देखो क्या डेट है. Just find out the date in this matter. Otherwise, tell the registry to list this in the last week when entire week will be miscellaneous.
Obliged, Lordship.
Milord, Senior Advocate Sanjay Hegde, he actually got admitted in the hospital yesterday after briefing for a minor surgery. And he has requested me to, take an adjournment for any date on Monday or any date.
No date. Are we?
Milord,
He's
still in the hospital. He's still in the hospital.
There is law of drafting. There is a law of pleading. There is a law of...
I've gotten instructions to take an adjournment. He's in the hospital right now.
Who?
Sanjay Hegde, Senior Advocate. That's why. Otherwise, I would have... Milords, then I'll argue, Milords. Then adjourned.
Urgent Sunday
Please, Milords. Milords, I've...
क्योंकि हम मीडिया में देना है ना कि pending petition pending.
Milords, I want to withdraw the petition. I've received instructions from the local council. And withdrawal application was circulated 13th May.
Non-counsel for the petition seeks and permitted to withdraw this petition with any liberty.
No liberty, Milords. Obliged, Milords.
Please. The trial court finds, Milords, only phonetic similarity. I sell online and I sell as Flipkart by internet. Please just have a comparison of the marks. This gentleman has had a registration since 1984. It only manufactures a few products. Products are different.
Suffering an injunction.
Yes, Mr.
For last 8 years.
Yes, Mr.
You yourself in your
In fact,
written statement say that you conceived and started marketing the products in 2017.
Yes, Mr.
You suffered an injunction within a year.
Yes, Mr. And I was.
Why will we interfere?
I was permitted to sell. That's only for one reason. I was permitted to sell from then till now, and I've been permitted to sell till today.
No.
But please only consider.
No, sir.
Those.
Now interim orders by the.
Our worry is that now from where this Flipkart word has been used.
I have always used it. That is the point. So there are two questions.
No.
Yes, Mr.
And now you want to have another litigation. You are not the original Flipkart.
I am the Flipkart. I am Flipkart. That's precisely the reason why.
ये मैन्युफैक्चरर है मार्क
अभी एक सेकंड में
नोट कर देते हैं
कर दिया
You are the original Flipkart.
Yeah. On that there is no.
God knows the kind of the way you have been masquerading.
application apart from trademark law.
Yes.
Under competition law, this becomes an unfair cornering of the market.
May I satisfy your lordships on that? Let's stay to it.
Absolutely no.
May I step back? And therefore, your lordships will only consider.
It is not. It's a finding of the High Court
Yes.
that they also have their products through the Flipkart platform.
Yes.
So if they are also using the platform for sale of the product,
Yes.
you are the platform.
Yes.
You are using a product which appears to be, admittedly, you agree, phonetically similar. All right, the High Court, both courts have held that they are phonetically similar. And you feel that you will get it, we would permit you to operate on that platform just because you say buy Flipkart.
Well, let's go to,
Next time anyone will type their mark, your algorithm will bring up this product along with their mark.
I'm not going to run away.
So we are not going to allow you this use of
just request your lordships to consider, Mulad, I have a proposal, and that perhaps Mulad can in fact resolve this entire issue once and for all for both of us. Once again. No, your lordships are right. Mulad. May I therefore, Mulad, just three broad propositions. Yes, Mr. No, Mulad, I'm not
become a Flipkart.
I'm not even saying that.
Flipkart. You don't know you are adopted child of Flipkart. You are the original one.
No, your lordships.
What is your DNA?
I have always been marked. Your lordships are right. I use a capital Q. They are MARC. MARC in the ordinary course is mark. The learned trial court finds there is no visible similarity. There is phonetic similarity. But please consider phonetic similarity applies when the trade channel is I walk into a shop and I ask for mark.
I'm also, apart from that,
yes,
at least by there is a visual similarity also. There is a visual similarity with the Q being written as if it's a mirror image of the.
I'm so grateful. So therefore, I have a solution which can actually resolve all of this. We had made that suggestion and it can actually resolve it for only two reasons. Your lordships will only consider the question of law perhaps, and please permit me to just make that point. There is a class which is electrical goods, which has class 7, 5, 9 and 11 and 7. Your lordships are right. There are several goods in that. Admittedly, they've made 4 goods out of that for the last 40 years. Today, effectively,
you can't do.
Then would your lordships only consider?
They are similar classed goods.
Absolutely.
This law is clear.
Yes.
If it is in the class and the class is a genus of goods, we won't allow a similar or dissimilar, a deceptively similar mark in this.
Your lordships
it will create confusions.
Your lordships are right. Therefore, offer.
You use it in other classes, no problem. They are in electronic goods. You prepare cosmetics, no problem. But not electronic goods.
But your lordships only consider.
I have a this, that, they are all.
I have a suggestion, and that's why I said, there are two legal questions. One, of course, has. May I just offer, if your lordships will consider, I am willing to change everything so that there is no confusion. Please consider, I am Flipkart. I don't really need mark. Millards, I have a brand of my own.
You use
This is a sub-brand.
I have no problem with Flipkart. If they want time to exhaust their goods, I have no
You
problem with
go
that.
to
They must change
trial court.
mark.
Yes.
Go to trial court, tell that you are ready and you will never use this mark.
Yes.
And that you have changed your name to so and so. They will say their suit is infructuous.
Millards, in fact, this is exactly what we had offered, but somewhere, Millards, there is some reluctance on the ground. I was only hoping with your Lordship's intervention, we could resolve this entire suit. I have two proposals for your Lordship's, Millards, only to consider. And if this is in the backdrop of that question that your Lordship rightly put to me, it can create confusion. But your Lordships will also, Millards, have also commented on people squatting on an entire class by only occupying a small portion. On that, Millards, therefore, I'm willing to rebrand completely. I have stock, Millards, which is in the pipeline and stock that is available. I can also exhaust that. But if your Lordships could consider...
No, you have been unfair. The Delhi High Court permitted you to sell stocks in 2018 of the existing stock.
Yes.
Thereafter, in notwithstanding an injunction, you decide to prepare and brand products in the offending mark. That's your risk and cost.
Perhaps, Millards, there is, Millards, the record will demonstrate, Millards, it was done with their knowledge, with their consent, and I was keeping accounts. So today, Millards,
That's a matter of trial.
Absolutely.
That is a matter.
Therefore, would your Lordships only consider, Millards, just to balance it, please consider sending us to mediation. We can actually resolve it. Otherwise, Millards, that larger question is something, as your Lordship notes, can actually be examined somewhere, but in not
Because
in a matter
4
like
times
this.
we've done this.
And
4
Flipkart-
times, it's not
As the
possible.
Honorable Chief Justice observed, go back to the trial court, propose the mark and say that please permit me to operate the mark.
I was only
work
hoping,
on that
Millards,
mark.
We may
Whatever.
actually finish
This
the
is-
entire suit here with your, well, a small nudge from your Lordships may actually help us. May I only request your Lordships to consider?
Unfinished, the entire
Your Lordships only consider.
they will have payers for compensation and accounts.
That's why, Millards, we can resolve all of that. Your Lordships consider then standing this over by a week. I will reach out to my friend. We will try and see if we can resolve it. Otherwise, Millards,
Now, Mark, we've done 4 times. Well, Mark, they must stop. Flipkart, I have no
No,
problem.
no, they, I think, just see what.
No, Malas, they're saying Mark by Flipkart. It's dominant.
No.
I am 240 crores selling on their platform in 17 since 84.
Forget mark.
84.
You can do one thing. Remove MAR, just keep Q.
Millards, we'll take that. Millards, would your Lordship hand it over by a week? Millards, I'll take instructions.
There shouldn't be phonetic similarity like this.
I see what.
Who I have no problem.
Mark and on the online platform, you know the sort of
Your Lordship,
created algorithms that are used by your company.
Millards, would your Lordship then stand it over?
Just because they have bigger fish,
Your Lordship.
it's not fair.
I'm so grateful. Millards, Millards, I have been injuncted till today. I'm only requesting, Millards, if your Lordships could have it on Monday then, Millards.
For what?
Millards, I'll make a proposal. We'll try and see if we can
And
resolve it.
Mark, they have to stop. Anything else, I have no problem. I am agreeing right now.
Then may I-
Dispose it of, you can always make a proposal.
Millards,
All that
Like I
will,
said, Millards,
you
once
can
in a while-
record your intention to make a proposal.
Lordships are right. Millards, the only reason I was, Millards, and I'm emboldened a little, Millards, only because of what has fallen from your Lordships at times when both parties are before your Lordships. Millards,
We've
that
gone
carries
4
some
times.
weight.
Millards, 4 times we've gone.
Millards, we were not before your Lordships 4 times. We are before your Lordships for the first time. And that's the only reason I'm only requesting your Lordships indulgence. Please have it next week.
But
Try and see.
what, Millards?
I'm sure, Millards, we
When it comes to mark and trademark identity, you should be more commercially sensitive than emotionally sensitive.
your Lordships are right, Millards, and
You should know exactly
as
where.
of today we are, Millards, on a lighter note, we are marked persons. I'm cognizant.
They have a dominant. Flipkart is their brand.
Family marks, etc., there is an emotional.
No, your Lordships are right. I also have, Millards, subject to your Lordships.
Commercial artifices, you can always change.
Millards, then may I offer a solution? Millards, it in fact puts an end to everything. I have an affidavit which sets out the details of my products. Would your Lordships only permit me to exhaust? My friend is very fairly.
I don't mind. Now 3 months, my lords may give them. Let them exhaust.
May need.
That's
there
fair.
is more time.
Can't be more than.
I've got that. Would your Lordships just permit me to file it? I'll hand it to my friend. Let my friend.
I don't mind. Whatever
Any
time my
questions
lords
on that?
feels reasonable, I will.
Absolutely.
I thought 3 months is plenty.
I've got an affidavit. Millards.
I don't mind.
They should be out in little.
No, of course they'll be out. No difficult. Let them file an affidavit. My lords may grant time.
Some counsel for the parties. We are not inclined to enter in the impugned orders passed by the trial court as well as the high court. The special petition is accordingly declined. However, in the facts and circumstances, this case, the petitioners are permitted to use the subject trademark. Trademark
No, exhaust the products, existing
Exhaust the product bearing the offending mark. Bearing the
offending
mark. Bearing the
Offending mark.
offending mark. The accounts before the court. Within a period of 4 weeks, and thereafter submit a compliance report to the tribunal.
I'm so sorry. Well, I've got an affidavit which tells your lordships what is the stock available. We may need a little more time. Well, I'm only requesting for that indulgence. Mr. Rodgi will show you.
4 weeks is enough.
Well, 4 weeks. Endless.
Quick your algorithm a better way.
Well, algorithm,
You will take 2 weeks to submit.
algorithm is not a problem. Well, the stock which is already in the pipeline, well, that's the only place where
What happens is that we manufacture it from outside. So we have to give advance orders to people to manufacture. So we may have some ready product today, and those chaps are in the pipeline. If I don't take those, I will face an action for damages, which will. So that's one.
In stock today.
Well, that's 6 weeks.
All right.
Kindly give me 3 months, I will get.
8 weeks. 8 weeks now. All right, thank you very much. 8 weeks. 8 weeks, Mr. Rodgi.
Very good.
Got 2 months. Great. License.
Both are there, my lords. This matter is already, my lords, reserved, my lords, for.
No. In this case, only show cause notice.
No, my lords, there is a adjudication order also, my lords. It is a adjudication order, my lords. I have annexed the.
Campground. What was the application we have also? Implementation of the revocation order shall remain stayed.
Yes, my lords.
It's the same order, but then attack which one?
Hello. Hello. Please, one. Item number 30, your lordship. Lordship, this is a matter arising out of the elections of Punjab and Haryana Bar Council. Lordships had given past orders, which was on 18th of November 2025. May I just read that order saying that the election should be conducted in a time-bound manner, and 3 expressions were used: just, transparent, and fair. All 3 have been violated. I'll just demonstrate how, your lordship. I'll read quickly, I'll go through the list of dates. Lordship, there is a judgment of this Honorable Court, that is Lalit Mohan Pandey, which is on 27th of April 2004, saying about the counting of preferential system of voting, which is hair clerk system. And it has got 2 things. One is the quota, and when there is no quota, then it is the proportional representation. So it talks about 2 things. Lordship, after that, there was my lordship's order passed on 18th of November 2025 in M. Vardhan versus Union of India, under which the elections notification was issued. Subsequent to that, in Yogmaya matter on 8th of December 2025, my lords passed an order saying that there should be 30% reservation for women candidate in the State Bar Council, 20% by way of election, 10% by way of co-option. So this is the women candidate. I'm only confining my argument. This whole writ petition is confined to the women candidate. Subsequent thereupon, on 16th of January 2026, there was an order passed.
Confining to what? Women candidate.
Yes, your lordship.
You are confining to
only women, only the reservation issue of the women candidate.
Dhulia's committee.
Yes, your lordship.
Have you approached the Justice Dhulia's committee?
Yes, your lordship. We did. That is Annexure P10. And in between, what happened interestingly was that the first preference, when the first preference of the voting was complete, then counting was stopped for 2 good days. And it was in between the counting.
Most of the High Court former judges were given to Punjab and Haryana.
Please don't make this wild and.
No, I'm not making that. Lordship, I'm only reading from the documents. I will not state a word.
Who doesn't know Justice Randhawa and Justice Jayashree Thakur and Nirmaljit Kaur?
It was Justice Ranjit Singh, I think.
Ah.
Ranjit Singh. Justice
Randhawa.
Ranjit Singh was there. He's Justice Randhawa. I mean, I know.
Best of the former judges, whom I at least personally know.
Yes, Your Lordship. So Annexure P.10 is my representation. Prior to that is Annexure P9, where a clarification was sought. May I just read, Your Lordship?
I know.
May I read Annexure P9, my lords, at page 151. This is an intimation regarding conduct of election under single transferable vote system and clarification on implementation of women reservation / representation. I'll just read this letter, Lordship. That will make everything clear. High-powered election supervisory committee, this is Pan-India, has issued clarification on the above noted subject and has clearly held that election shall be conducted on...
Justice Dhulia's order?
Justice Dhulia's order is not here. That is of 9th February 2026. That was not with us. It was not on record.
No. Have you challenged the election of Punjab and Haryana Bar Council before Justice Dhulia's committee?
No, it is, Lordship, I'll just read. No, it is challenged before the election committee, high-powered election committee of Punjab and Haryana. This is a representation, which is Annexure P10 is the representation.
Representation to the high-powered election.
Lordship, may just permit me to read Annexure P9, my lords. Lordship, high-powered election supervisory committee had issued clarification on the above noted subject matter. May be just excused. And has clearly held.
What is there in P10?
P10 is my representation. Huh? Representation.
What is there in? Please read the representation. What is the head and tail of this representation?
Yes, Your Lordship. The head and tail is the breakdown of Hare Clark electoral system of counting. Their first preference voting was complete. Thereafter, the counting was stopped, and an elimination list was prepared, where the lowest candidate becomes the first candidate, the second lowest becomes the second candidate, third, fourth last fourth, and fifth last fifth. So it is a reversal of the counting system, which is supposedly on the proportional representation. Now, I will just submit, Lordship, how a quota is fixed. The number of votes which were polled.
Under the current counting, women can
What is the name of our matter?
Chetan Verma was the BCI.
13.
Samita Devi versus
have been accommodated.
No, Lordship.
Yes.
We are the
169 page.
Yes, Your Lordship, that is the final result.
So declared result.
Lordship, may I?
19 to 23 persons who as per.
Yes, Your Lordship, what happened is that 17, 18 are also by way of a writ petition before Your Lordship, because the counting, whenever there's a tie. Lordship, just let me present my case, Your Lordship. The Hare Clark system, may I just read? I'll read the nitty-gritty of it, how it works.
Sitting in appeal, madam, you are in 32 petitions. Wherever you want to go, you go there, otherwise we are dismissing it.
No, Lordship may just then give me the liberty that my representation may be heard in a time-bound manner.
So who is to here tell us?
Lordship, the representation right now is before the returning officer.
Decide, because we don't want some advocate to sit over the decision of the former judges who have been very senior judges of the High Court.
Lordship, let it be before the high-powered supervisory committee.
Go to Justice Dhulia's committee. We will permit you to go there.
Lordship,
I beg to appear in 32, my lords.
You also go.
Lord, only thing, Lord, there is a statutory mechanism as well, as far as election disputes are concerned, under Rule 34, that, my Lord, Bar Council has to, my Lord, decide this issue. So, my Lord,
Who then you notify your what is?
Lordship, it is.
We will do that.
Lordship,
There's
we are
a
here in the
election
32
committee
petition.
which will go into it. Dispute resolution
Lordship, that
committee.
is only because orders have been passed by
I
my
tell
lord.
what's the problem with all these matters.
Lordship, it
Hold it, just a minute, draft order before we find.
before your Lordship.
Before Lordship declared one more thing.
We will not touch even a single line on merit.
No, nothing on merits, my Lord, nothing on merits.
Lordship, let
May I just
Lord,
submit what has happened?
Lordship, let me complete, Lordship, let me complete my submission. What has happened in this particular case, Your Lordship, is the reservation, the eliminated women candidate. There's a list published with R on top. Lordship, Lordship, the flaw is right from the initiation by having a common ballot paper. Lordship, when there is a single common ballot and there is nothing called a preference, a first preference to be given to a women candidate out of 5 reserved and 18 general candidate, is Lordship, the normal psyche is that people go and vote for a candidate who they think that he or she is going to win.
Right.
A women candidate, the counting never took place, Your Lordship. This is my case. The counting even before the counting commenced.
These 3 writ petitions.
Lord, may I just, my Lord, on 32, my Lord, may I just submit, my Lord?
On 31, Lord, I have to make one submission.
No, just 2 minutes it will take, my Lord. If your Lordship, just 1 second. So if your Lordships are pleased to have, my Lords, my writ petition, which is item number 32.
Yes.
Lord, we are not making any allegations against any of the committee members, and my Lord's Lordship's judgment is more than welcome, my Lord, reservation. But my Lord, the inadvertent, my Lord, injustice which has happened, I just want to point that out. And my Lord, that
Justice to whom?
my Lord, to the candidates, my Lord, because the procedure which has been followed.
Male advocates or female advocates?
Lord, as far as I am concerned, I represent a male.
Exactly. Yeah, we know it that is an interesting rivalry.
My Lord, we are not against the reservation, but what has happened here?
Mr. Kamath,
Yes,
look at our predicament.
yes,
Despite the fact, according to you, we have unfairly or maybe.
No, my Lord, we are not saying that. We are not
Let
saying
us
that.
use the word unfairly.
No, we are not saying that.
Let us use the word unfairly. Despite the fact that we have unfairly given advantage, not undue, unfair advantage to the female advocates, ensuring their representation to the extent of 30%.
Correct, Lord.
They are unhappy.
No, only because of the transparency. It's because of the transparency, Your Lordship.
Your unhappiness.
Lord, we have no dispute. We have no dispute. There
Lordship,
is some problem. I just want to.
Lordship,
point out.
it is not.
One second, Lord. Lord, just have a look at page 12, my Lord. Just
Therefore,
have.
what we are proposing.
Yes, my Lord.
Justice Sudhanshu Dulia,
Yes, my Lord.
along with Justice Ravi Jha, former Chief Justice,
Yes.
and
Yes.
third member was
Mr. Giri.
Mr. Giri, senior advocate.
Senior advocate.
Yes.
We had appointed them as high-powered supervisory.
Supervisory
We are
committee.
directing them to notify that committee as the appellate tribunal or the election tribunal and permitting you to approach the tribunal. Raise your grievances. They know each and every in and outs of the.
Yes, my Lord. Because ultimately, my Lord, that quota system, how it has been actually, what this will, my Lord, span across states. So, my Lord, Lordships may have to issue some clarification. I'll just point out the difficulty, my Lord. But just have a look at this.
Justice Dulia to
The proposal that you are giving for modification of the quota from 24 to 18,
No, I'm saying.
then your sisters will say,
Yes.
for them the quota should be 6. Because they are only for 5 seats.
Seven actually, Your Lordship. 2 by co-option.
Who are co-option, madam? We are speaking for your advantage. The quota in competition through election should be number of seats that you are fixed plus 1. So Mr. Kamath says that if 5 goes away, why should our vote be divided by 23 plus 1?
Lordship, may I
If that logic is taken, then their vote should be.
No, my Lord.
Lord,
What we are saying is something else, my Lord. Under Rule 29 of the Bar Council rules, my Lord, only the surplus vote.
Julia's committee, and we have endorsed that.
Yes, my Lord.
It's a common ballot.
Yes, my Lord.
Irrespective, and that's why we consciously not use the word reservation, but accommodation.
Correct. Accommodation.
The number of seats remain the same.
Absolutely.
And thereby tentative.
But the
Subject
problem
to what
happens.
Justice Julia's committee says.
Yes.
The quota also remains the same.
Why you want that committee to examine? Now in a different form.
I had one thing to
Because
say.
they have to take a call on pan-India basis.
Yes, my Lord.
Maharashtra, the problem may be
This
slightly
problem is
different.
happening pan-India.
Maharashtra, there are two ballot papers.
There are several unaccounted votes now, my lord.
Lordship-
About 10,000 unaccounted votes, my lord.
That's why
It can never be in a democracy. Every vote will have to be counted. But the procedure which has, my lord, resulted,
therefore-
about 10,000 votes are not counted at all.
This problem might be on pan-India basis,
Yes, lord.
maybe in a different shape
Yes, lord.
and having different consequences.
Yes, lord.
So
I
go there and
I was going to submit
Lordship,
this on this, on what fell from my lord, the Chief Justice. The only issue about designating the committee itself as an election tribunal, my lords, there are two issues there. 34 has a certain procedure to be followed. Rule 34, that's one, my lords. Number two, the moment it is designated as a tribunal, my concern is, on a mandate of this honorable court, several directions were passed, committees were constituted, the election has gone on. Today, I don't want hundreds of petitions to now come, my lords, on the ground that there is no an election tribunal. That's the real problem.
Continue to work. It's a 5-year tenure. It's not that some 6 months.
Yeah, I know. But
whatever 5-year, 3-year, we don't know. But whatever tenure is there, the election tribunal will make.
Lordship,
Maybe suggest something, my lord.
These are all matters where
something.
then and there contemporaneously no issues were raised. The moment somebody lost, they are raising it.
Lordship, that's not correct. That is not correct.
Lordship, can I speak? Can
you just hold on for a minute?
Lordship, only.
There are some submissions made at their end which are with regard to structural incorrectness.
Some complaints are raising. Yeah.
In any case,
Lordship, may I just add to this?
Platform have to be provided. These
I
are
understand.
issues which can be decided under 32.
34, my lords, talks of a tribunal to be constituted by the Bar Council, my lords, with certain qualifications of persons who need to man it. So I was.
What is that great qualification you like to know?
Three councils.
We are appointing former chief justice.
That is true, my lord.
Former chief justice.
Lordship, actually problem is that ki Haryana gets normally only women's get only 1 month. And the gents are getting 5 years, minimum 7 years.
Problem is that
and sir,
the word woman in Haryana is anti-climax. So that's why it is not, they can't digest it that we are providing.
yeah, they are not adjusting. Yeah, you are right, sir. The males are not adjusting this reservation. And after that,
But
sir.
we thought you people will not come before us. You will at least celebrate it.
Yeah, sir. We celebrate, sir. And congratulations to.
Question is not who lost out of you, who lost and who won. The question is that how many women have been able to understand.
Yes, sir. Only problem is
How
that,
is that?
sir, the process.
Lordship, may
Their votes, second preferences were considered and given to the.
No, that is correct.
Advocates
Second
are
preference was
not
never counted.
understand the process of voting. They giving it, sir, first preference to the males and the second preference, maximum second preference to the female candidates, sir.
My lord, may I suggest only one thing, my lord?
Sir, Lord,
since
I have-
high-powered committee, my lord.
Chief Minister भी lady करती है.
Sir, advocates give us
High-powered
a
committee
second
itself was
preference,
part
sir,
of the
and second preference is
But if the
not
bar council, my lord,
calculated,
can put a
counted.
dedicated team, my lords, of this tribunal, it will be much better, my lord.
Second preference
want to
is not
harass the
counted.
committee, my lord.
Sir,
So let
this
the
is
bar
the
council, my lord,
problem,
appoint
sir,
a committee
and
of
maximum
34.
female only based on
We are
second.
not experts in election law. And we'll request Justice Dhulia to on priority basis.
My lord, only,
Lordship,
only,
may
only
I just
request
submit
was,
one
only request was, my
once-
lord, since the committee itself was a part of this drafting of these rules, etc., my lord. Now, if, my lord, the under Rule 34, lot of fresh pair of, my lord, eyes can look at the procedure.
We can say that they will appoint one former Supreme Court judge along with one.
To them, whatever, my lord.
I'll do one thing, my lord.
Lordship, may I
Please
just.
have it on Monday. I'll
Lordship,
come back.
may
discuss with them.
I make a submission, your lordship?
My lords can have it. Monday. I'll just discuss with them.
No problem. We have no difficulty. We can keep on Monday.
Yes.
But make sure that a former Supreme Court judge, one former Chief Justice of the High Court.
Yes, my lord, let them constitute a fresh committee, my lord, because this will
I'll
be a
discuss on
dedicated
these lines.
committee for all the disputes, my lord. We don't embarrass anybody.
One eminent senior advocate of the Supreme Court bar.
Yes, my lord. Yes, my lord.
I'll discuss with them, my lords.
Yeah, that's fair enough.
I'll let them know. I'll also have a word with them. We'll come back on Monday, my lords.
Grateful.
It can be even 5 members because there will be many elections.
Many election periods throughout the country.
where they can sit in two divisions or something and.
There can be, the minimum composition can be 2 members.
Yes.
And then you can think of 1 former Supreme Court judge, 2 former Chief Justices, and 2 eminent senior advocates of
Yes,
the
my lord.
Supreme Court.
That will be fair, my lord.
Four members.
I'll just
Sir,
discuss.
we
with them.
want
I'll place it.
2 ballot papers.
There should be.
Next election or these
I'll come back on Monday on this, my lord. I'll come back.
separate ballot paper we want,
Next
sir,
year.
for women reservation.
Next.
Lordship,
Otherwise, there is
there'll be-
no.
Since there'll be a
no
fresh
benefit, sir.
committee, Lordship, since there'll be a fresh committee has to be constituted on Monday to look into the grievances, I just say from the inception, I'm just pointing out, highlighting 3 defects. Lordship, the name
All that
of the
committee to see,
candidate.
my lord.
Lordship, the very name of the candidate, her name.
Yes, sir.
Is petition number 5.
Sir, you simply ignore where certain other, everywhere this system failed. At least we have been through our.
Lordship,
Not through judicial order, through judicial persuasion. And only exercising moral authority.
Yes, your Lordship.
That bar have been, all members have been so graciously agreeing to us. We have been able to achieve.
Lordship,
something.
I'm only requesting, had there been transparency, your Lordship.
Only
It is not a question of victory or defeat. It
differences
is
will have to be ironed out.
transparency.
On Monday,
Yes, Monday.
bring the proposal. Now go to 5 members. This will be the composition. Huh? And all senior persons. All senior persons.
Noted down. I'll discuss and come back.
Grateful.
Obliged, your Lordship.
Very well.
Sir, at least my name is not correct.
Her
Correction
name-
is not allowed
Lordship,
there,
she
sir.
is Suman
I
Daya.
am Suman
And
Daya,
her
known
name-
as Suman Daya, but
And
my
that
name is
is how the
only
votes also
Suman in the
change.
ballot paper, sir.
She is
Let us-
a
let us-
member of the State Women's
Let's hope
Commission,
for
your
the
Lordship.
best.
Obliged.
Okay, sir. Thank you. Thank you.
31, item 31. Those
Last 15th hearing, the matter was listed but not taken up. I am already,
Now, what can we do? Every day this petition, Allahabad High Court, unfortunately, entire High Court is being now run by us.
Lord, Annexure P11, Lord, just two
2020
full submission.
So look at the High Court, if you ask for
One
the details.
observation, I am before IBC. This is the only asset. If this writ petition is not decided, I will be in liquidation. This is why, my Lord, I am invoking extra. Lord, just one observation for the Honorable High Court that please try to decide it within some time frame, my Lord. That's the only prayer.
Entertain the petition, the Article 32 of the Constitution, the petition so advised may approach the High Court and make out a case of for out of turn hearing of the pending writ.
Some time frame, Lord. If
No question. We are no every year. It's not first time.
Lord,
Every day we have 3-4 writs.
Lord, NCLT is already more than 330 days. This liquidation is hanging on my head.
That's why we said make out a case of out of turn hearing. You attach all these things.
Please, great.
Item 33.
Deep freezing of cyber.
Now go to high. Yes, item 33.
Lord. This 33? 33?
33.
Obliged. My Lord, my grievance is simply this, my Lord. Now, these complaints.
We have already dismissed identical petitions.
This
We will
one,
go to High Court concern.
Yes, I'll tell you, Lordships, I've seen that order, my Lord. The Lordship had said in that order, go to jurisdictional High Court on a case-to-case basis. I'll tell you, Lordship, the difficulty, my Lord. This company, there are similar orders passed in Gujarat, Uttar Pradesh, Punjab, Karnataka. Now, the problem is.
More the merrier for you.
Yes, my Lord.
More the merrier for you.
No, my Lord, not for the litigant, my Lord.
Oh, litigant has to suffer.
I'll tell Lordships why. Can I just.
All that defense and sub stories.
How many transactions and how many crores?
All sub stories will come later.
Can I just respond to that? Can I just attempt to dispel that notion? Just
No.
Just give me one sentence. That's all. Just one sentence.
You can take a lifetime. You
Yes,
won't be able
what I'm saying is this. What is happening is this, my Lord. This is I'm not taking too much time. This company is entering into an agreement with these people. After giving us the money, they still, after filing the complaint, they still continue with us. So what is happening today is this. Suppose the complaint is for 1 lakh, just hypothetically. The bank comes, direction is given, my bank account has 50 lakhs, for example. They come and attach the entire bank account. Lord, I'm not able to pay the salaries, the whole functioning comes to a standstill. Now, Lordship.
You understand?
Now,
They will rationalize the attachment.
No, which is
Go to the respective high.
the question. Then the question may arise: why can't I say the same thing to the Honorable High Courts? Now, since this issue is happening in state, now I am based in Jaipur. So now the uniform policy, because this is what the cyber cell is doing. The bank account has there's a case in Delhi High Court, my lord. It's a stark case. I'm just telling you, Lordship. I've got the order. 200 rupees was the complaint. A company's bank account of 90 lakhs is attached. The Honorable Delhi High Court directs the Union Home Ministry, please come out with an SOP, consider this judgment, please come out with an SOP. So all I'm requesting, Your Lordship, I'm not asking anything specific for this. This, on a consistent basis, affects the functioning of our company and many others. Now, of course, I'm advancing my case here, my lord. Now, for this case, for example, like I tell Your Lordship, there is one complaint where the complaint, even going by the complaint is for about 25,000. They've gone and told Paytm, just cancel my payment gateway. So I can't receive any money. How will a company function, my lord? It's not a cyber crime in that sense. When moment you say cyber crime, my lord, it takes a different connotation. Here, this is a company.
Cyber crime has got no specific identity, but for the fact that it operates on the digital platform.
Yes,
that's all.
Absolutely.
But the basic ingredients remain the same: dishonesty, cheating, conversion, etc.
Correct.
The biggest difficulty with cybercrime is the quickness with which the assets move online because of the interconnectivity of the entire monetary system. Yes. Within seconds, money will move through 50 accounts across 20 countries.
Yes.
And that is why the precautionary principle requires maybe disproportionate attachments and thereafter resolution at your behest.
My lord,
it's not something
my only
unreasonable.
The only attempt to respond to this way. Now, Lordship is right. Cybercrime. This is peculiar in that sense because time is of the essence. I understand that. But my only request is this, my lord. In a situation like this, where the complaint is for 1 lakh, the police comes and cybercrime cell comes and attaches an account for 1 crore of a company. How does the company function? Lord? There has to be some guide. So my prayer is not.
We understand that, but then the agencies require to immediately stop the transactions, because there will be, by the time they keep it at 1 lakh, that account will be operated 1 lakh times with 1 lakh each. Do you get the difficulty? And that is why they disable the account.
Which is why.
So it's not only, just see, sir, when cybercrime takes place through digital channels and platforms,
yes, ma'am,
it's not only the quantum of one digital intervention. It is the pathway. So it's when they block it, it's not only to real amount, but disable the pathway. So these are things of investigation, and we have to leave it to the wisdom of the
No, I'll tell you, Lordship, like I know every solution, but here in this case, there is a case in this example I've given.
So
the complaint
this debate should be in the first place before the High Court.
Then may I request your Lordship, my lord,
go to the High Court.
I don't think I'll be able to persuade Lordship now. Lordship may allow me to withdraw.
You won't be.
One second.
To withdraw this petition with the liberty to approach the jurisdiction High Court.
Oblige. My lord.
Not in item 34, identical issue. Pending consideration, my lord.
Are you supporting Mr.
I have never seen a SNP like this saying that the judge should not
God his client.
I'll point out what is the problem.
There is no point. If they have a discharge, you come before us.
I understand. Lock, stock and barrel, all accused are being discharged.
Let us see what.
Can you ask a court, my lord, not to pronounce judgment because some case is pending?
Because identical issue pending in that judgment of Prakash Industries, lock, stock and barrel, Lord, all.
Prakash Industries, sir, let us understand. Prakash Industry was decided in your favor.
The LPA decides in my favor.
Prakash Industries decided in your favor.
And then there's a stay.
We have not delivered a verdict setting aside Prakash Industries.
No, my lord has not.
Operation of a judgment does not, stay of operation.
He's only inter-se party, my lord.
Does not mean that the findings in the judgment are
gone.
are set aside.
Absolutely, my lord. My lord, may clarify that,
Plan
please.
is absolutely before the Supreme Court. It
I'm
is
grateful.
Absolutely before the trial court.
I bow down to that proposition. My lord, may just clarify that.
Why should we clarify anything?
Because, my lord, that stay is being cited to say that
When we saw this at the request of the Directorate
I-
of Enforcement, it is the Directorate of Enforcement hand in glove with the accused.
I bow down to that, my lord. I also had the same thing when I read it last evening. But then I inquired from the officers, why is this kind of a petition being filed? The apprehension is, and it is born out of immediate series of past orders.
Then they will
where-
challenge, Lord, if something happens, you challenge.
How can these?
We preempt.
Sir, one
Lord is
thing,
right.
please understand, an operation of an order stayed
Yes, my lord.
does not stay the findings of the
Absolutely.
authorities.
It does not even lose its precedential value.
Lord, sir, you know that.
Jurisdictional High Court,
Yes, my lord.
under which the trial court, which
Is bound to follow. In fact, the precedential value continues, my lords have said in many judgments.
this argument, Mr. A, should be made before the trial judge.
Lord,
Lord, the
Every
trial judge has
judge
to be
comes
allowed
a
to pronounce an order. Right or wrong, it will be challenged.
And what did the trial judge want? He wanted some data from you
Yes.
to help him.
That has been given, my lord. All that.
They were not giving,
The learned
and they
people
said,
have
don't
mentioned-
pronounce orders. He dismissed that application. This is not
may I
gross.
only-
What is happening to ED? I mean, this is gross what they are doing, Lord. Gross.
May I only point this?
Wasting time of this court, Lord, is all I can say.
My learned friend has.
This court has better things not to do.
You should have applied in that case where we stage patent
In
granted
fact,
by
Mr.
this court.
Wadgi, you should not oppose this application. You should say, let there be a stay of the proceeding.
Actually,
That's for your client.
interest of the parties.
Your client
You know what?
actually benefits.
I appreciate,
the enforcement
but they,
secretary.
I appreciate, but they moved an IA. The judge Milord has heard on charges. They moved an IA, don't pronounce judgment. It is that IA which is rejected. The judgment has to come, Milord, if it's against me, I'll go up.
In
If it's against
some
you, you
cases,
go up.
my lords have taken the view that if an identical issue is pending before a superior court,
Different state of affairs. This is not an
We all
identical
like
issue
to say-
which is going to paralyze all trials.
Every
throughout
trial
India.
should stay because of a judge.
same coal block.
Yes.
So like if you say that both the parties may request the trial court to adjourn the proceedings for some time. Meanwhile, SLP will make an endeavor to decide the.
To expedite.
Very
I'm
difficult.
I'm
It
so.
took a lot of time because there's a diversal of appeals. Matter is Milord of a very complex nature. Why shouldn't Milord the judge decide?
Every coal block case,
Why
my lords,
should a judge?
will fall if the view taken in this case is.
Even
sustained.
Only to avoid multiplicity of.
Milord, there are cases across the nation. This is one case.
No.
Whatever the judgment be, I'm sorry, Milord.
Whether
I
application
submit.
letter amounts to proceed of crime.
One second, please.
What will happen based upon this, because there is now the view formed by trial courts mostly
Yeah.
is to discharge the accused.
Yes.
Understandable, that,
Yes.
that view is also, can be a correct view.
Yes, could be.
But if those kind of orders are passed on pan-India basis, it will generate a lot of litigation.
Yes.
We are only on that point.
Special court, only one court is dealing with.
Milord, with great respect, Milord. Everybody is entitled to have a view of the court. Can the view of a court, Milord, because the law is in my favor?
Court view definitely will come. The court's view in any case will come. The only thing is to avoid unnecessarily.
And that is what has fallen from.
This is only in
the
one
Chief
case that he has
Justice.
filed this, Milord.
My lord,
There are hundreds of such cases.
My lord, the Honorable
Why
Chief
one
Justice
case?
has hit the nail on the head. That is precisely what is happening. We are, because all coal block matters pursuant to Manohar Lal Sharma has been centralized in this one court, my lord.
Now,
That court,
what is the next date?
21st May, my lord, 21st May. And that if Prakash Industry is expedited, all the issues in all coal block matters will get settled. And we will assist in the expediting. We filed the counters.
We are not affected by Prakash, it should go on.
Milord, in the High Court, their stand is reverse. That we are not affected because Prakash is pending. High Court should proceed.
No,
Here you come and
absolutely.
say, this should not proceed.
Absolutely not. My learned friend was not in High Court. I was in High Court. I conducted. Nobody said that from me.
One of the other matters.
My friend is here. This is what you said.
Not in Prakash.
Not in Prakash.
I am respectfully submitting, Milord, this is a very dangerous, Milord, precedent to say that the judge should not, Milord, pronounce judgment.
No, let it not be a precedent. It may be on
Whatever it
consent of
is,
parties, my lord.
Or whatever it, Milord, he will take a call, Milord. Why should any special treatment be given to one case?
In the peculiar
This is not
facts
the
of
only
this
case,
my lord, same very issue as to whether the allocation letter.
It will happen in hundreds of cases.
Not
All
hundreds,
cases.
only the coal block cases pending.
I submit, Milord, that this should not be entertained.
The question of law decided by this court will guide the special court in these pending cases and coal block cases, my lord. Therefore, my lord, there won't be multiplicity.
My lord, it is like saying
It
I
is
have-
underlying public policy. It's not an advance ruling.
What is the date in SLP 345?
Yes, my lord.
No, there is no date. There is no date.
3452.
There is no date.
Date, no date.
My lord, may give any date, my lord, our pleadings are complete.
The CBI matter should also be stayed, sir. Given the advanced stage of evidence, and then we will come in 60.
Lord, if your lordships are inclined to postpone this because of that case, the CBI case also must stop then.
All the cases.
It can't be, Lord, CBI will proceed
Lord,
against me.
CBI is
And
not
he has
before.
not it ever.
Lord, this is only on the interpretation of
I'm sorry,
proceed of
Lord.
crime.
You can't-
CBI, I'm sorry, CBI has nothing to do with this. They are in the PC Act case.
How can that? You are actually piggy riding on CBI. You want this to be deferred. CBI should also.
And they are in the stage of final arguments.
No evidence.
That is at the stage of evidence. Not even that should be deferred. I can't be put to double jeopardy.
CBI
One
is
man
not
says that
here.
that will go on against you, and this will, because you fear that there will be a discharge. That will be very unfair. If this is being postponed, even the CBI should be postponed.
Question of law pending in
That
Prakash.
also must be postponed.
Lord,
CBI trial. CBI trial is not along with this case.
not along with this. These are not joint trials.
This is because of
These are not
CBI.
joint trials. That the
This
law
case
itself
is
says.
because of the CBI trial. ED starts only after CBI.
The issue in
ED is to be deferred, then CBI must be deferred.
no, generally is the other way around.
Don't say no.
My lord,
This
proceed
is
of crime.
very unfair that you say one should be deferred and one should go on.
Because
being put to double jeopardy, my lord.
there is, my lords have already taken a view in several
CBI is
judgments.
also on 21st. Both should be deferred then.
There is no
And your
double
lordship may have it in
jeopardy.
July.
Money laundering is an independent offense. And my lord, the issue pending in Prakash has nothing to do with CBI. CBI is not even a party. Whether allocation of
Prakash will come only because of CBI, my lord. Unless there is a CBI prosecution, ED can't come in.
nothing pending in Prakash will impact CBI's prosecution.
Lord, kindly, my lord, postpone both of them and the lordship may put it in end of July. And
But you see, the problem is that CBI trial, we don't have any information, we don't have any idea about what is.
That's right. And CBI is not a party in this. Only the definition of
Lord, your
proceed of
lordship, no.
crime, interpretation.
For the same offense, you have CBI. For the same twist, my lord, of money laundering, you have ED.
It's not.
ED, piggy rights, my lord, only on CBI. And your lordships,
That have they complied with para 6?
Yes. In Prakash reply filed in the, a common reply filed in the main matter, my lord.
Say like this, the registry is directed to comply with para 6 of
the CBI state.
the order dated 16th January 2026.
You file an application because that.
Passed in
Because of this order, you postpone.
SLP civil number 3452 stroke 2026 and list all the SLPs. It can't be civil, it should be criminal.
It says, it is civil because of the, it comes from the attachment route. It is.
And list all the cases mentioned in para 5 of the above dated order on July we are opening. On 21st July 2026. The counsel for the parties be informed in advance. Next paragraph, since the matter pending in the court including SLP civil number 3452 stroke 2026 are likely to be decided on 21st July, are likely to be finally heard on 21st July 2026. the special judge in bracket PCF, CBI, in bracket 4 block cases.
Can adjourn the proceeding. Shall I?
Is directed to adjourn the proceedings.
In criminal case 1 of 2019. In criminal case number 1 of 2019. That
CBI released before same date before the same judge.
no, that is a
They are
different
stood together.
different case number.
He make that clear before the judge.
Is directed to adjourn the proceedings. In CNR number.
Yes, my lord.
In CNR.
CRC number 1 of
PNPT 11-000542-2019 and other connected matters for a date beyond 21st July 2020. You have mentioned other connected matter that will take care of. ये registry को बोलते हैं इसकी
not only one request, my lord. CBI is not here. In their absence, I don't want them.
Can I give the CC number?
Asking that
this matter is
whether
already shown on
I am dependent on them. They are not dependent on me. My lord, may
CC number, that case is also.
that was saying
instead of 21st July, it will be 29th July.
property or not. Property or not.
yes.
Comes into decision in Prakash.
Yes.
CBI judgment will also be affected.
CBI is a PC Act offense, my lord. It has PC Act
So
offense.
what?
Nothing to do.
What is the
In
problem?
any case, because the
What you were saying, CBI charge includes 420, 467.
That's right. That's right.
So the offense, whether the letter amounts to property, which they had falsely represented to obtain,
Yes.
comes into question in your proceeds of crime,
In the
will
420
also incidentally come into question.
420 case, my lord. 420.
So
Where-
Of a cyber fraud, my lords. I am being harassed from all over India, my lords. Just to be brief facts, my lords. On 13th of April, my lords, I am a small businessman, goes to Bombay.
Some unknown person came and returned your phone.
Yes.
And you did not, when the phone was stolen, no GD was lodged.
No, my lords,
Once the FIR gets lodged at Bidhannagar police station in Kolkata in 16th of April, on 17th you lodge the FIR here.
my lords, I have no, can I just,
You go on, this is the substratum now you develop.
my lords, first of all, I have no criminal antecedents, my lords, yes.
That antecedent will come now.
Yes, now.
There are 5 antecedents before us.
319 transactions.
From 5 states.
22 credits of 6 point.
Correct.
319 debits.
Correct.
And how I get
Listen,
to
6 crores.
you were a part of the mule account in the fraud. Now you are a part of the mule litigation.
My lords, I have never been.
Yes, stop being the mule in the transaction.
I am being, my lords, I am actually a victim. I made a.
You are right.
15th of April.
Every mule says he is the victim.
My lords, can I just point out, my lords, how I get to know about this, since my lords said yes, on 6th.
We asked you, who was that unknown Samaritan who returned your phone?
My lords,
Because we will direct the police first to custodial interrogation of that unknown Samaritan who returns your phone.
My lords, I wish I knew that person because I
If
kept on
you
calling
wish,
the-
and if you don't, then you will be subjected to custodial interrogation to bring out that unknown identity.
Not to, my lords, can I just point out what happened? 13th, I lost my mobile. I go to Bombay. I have even my flight tickets. If my lords want.
Doesn't matter. We want the name of the person who returned your mobile. If that name comes, he will be interrogated in custody. If that name does not come, you will be interrogated in custody to bring out the identity.
My lords, from all over India, I am getting notice. Can I?
All over India, interrogation will take place.
But my lords.
See, if had it been a case of say 1 or 2 transactions, one can understand by the time I reported to the police,
For 3 days.
my mobile was missing.
3 days,
This is what I
100 transactions.
out my SIM was
319
out, my lords.
19 transactions.
Yes.
Running to 6 crore 72 lakhs, almost 7 crore amount.
My lords, my SIM stopped working when I got my mobile. I had a dual SIM. When I go back to my hometown, I bring a put a new SIM, my lords. Then all the transaction come on 17. I immediately makes a complaint, which is there, my lords, at page 38 to 40 to the police. When I get to know this, all my transaction in my life was around 4-5 lakhs as per my business transaction. In 2 days, 22 credits, 319 debits of 6.72 crores, my lords. And today, my lords, I am getting notice from all over India. I am myself a victim of a fraud.
We have told you the missing link.
My lords, it can happen with anyone.
Exactly, it can happen with anyone.
My lords, please.
It can happen with anyone, but that anyone will tell you the person who returned the phone.
My lords, I immediately that makes a complaint on page 39. Please have a look at least, my lords, page 39.
That is the weakness of your story.
So, my lords, today, if my SIM is not working, my lords, how would I know that somebody would have done this?
Again,
The moment I
told
go
you-
to my hometown.
You will never know that, but you will know the man who returns your phone. He will know the person from whom
My lords, can I-
transactions originate.
Anyone can make this mistake. Someone loses a mobile, you call up on your number and someone can say, yes, I found your mobile, this is your mobile. Please. And today what has happened to me is 6.72 crores in 2 days, my lord.
So even if your mobile is misplaced, how somebody will have a password and then access to your bank account?
They are very smart. They hack everything.
They have everything, then what can we do?
My lord, today,
How the mobile number has changed.
Then better.
in fact, just see one screenshot how my mobile number was also changed, my
The
lord.
only way out is that people should stop now having mobile. That's the only way out.
On 13th April, when the
Please see, my lords.
the recovery email has been changed.
Yes, please see page 34. This is important. I lose my mobile on 13th of April, my lords. Yes.
This old phone, new phone.
Yes. Old phone, new phone, my lords.
Number is changed. I cannot be fault.
Number is changed.
By you?
I'm sorry, my lords.
When was this SIM card purchased?
New SIM, my lord, 17th of April.
No.
No, the
When
old SIM.
was this, which you misplaced on 13th April?
Yes.
When was it taken?
It was old. Old phone, my lords. It's not that I had taken it a day before. Long back. And please see page 34, my lords. And it's not that I was never thought that this would have happened. The moment I go to my hometown, when I get a new SIM, and today I am getting from 7 states, West Bengal, Punjab, UP, AP, Telangana, they're asking me to put in a police station. My lords have absolutely nothing to do with this.
When you came to know,
Go and help them.
No, today I'm only requesting no persistence. I'm
know
ready
that
to.
Why should we give you that
crores of
protection?
My lords, but
They feel that they should subject you to custodial
Honest-
interrogation, they should.
My lords, what I have benefit out of it, my mobile is stolen.
understand that
6.72
you
crores
did
has
not
come. I have
benefit
made a complaint to the police. What a normal
You
citizen
didn't
can.
bargain, you didn't bargain
My
for
lords,
the
can I
amount,
say something in
amount for which the commission that you took for the purpose of allowing your account to be used.
I am not allowed. I am not allowed. Please see, in fact, an FIR has been registered where the account has come to me and they have used this court's name also
Very good.
in additional documents, forged documents.
Correct. That is what, that
They
is,
digitally arrest
that in
Please
fact,
my
so,
documents.
that's what we are saying. It requires very intense custodial interrogation of your client.
My lords, he He is actually, my lord.
You want to pursue further, we observe that the nature of the crime and its ramifications require
This can
custodial.
with my client, it can happen with anyone.
Doesn't matter if it happens with anyone, they stand in the same footing with your client.
You can make a comprehensive representations to all the agencies. You can show that on the date when you purchase the SIM card,
Please, my lord.
you obtain the all details of your bank accounts from the bank. Attach them to show that as far as throughout the life you have been having a
I
transaction
can
of.
file it here also next week, please.
Why?
I don't know
But
next
we
week.
are police
They
station.
are not the investigating.
We are
agency.
police station.
No, I just wanted
Then-
to show that I've never ever.
No, you don't have to show anything to us.
You represent to them, they will, if they, probably if they are convinced, then they will absolve you.
Absolutely.
Is it 7 places?
My lord, today I have already got from 7. I don't know from how many places I have get.
Naturally, you are a part of an organized crime racket.
I am not a part of our.
That is for the investigating agency to say. Neither do we form an opinion for you or against you. We can assume ourselves the role of a police officer.
I'm only saying I will cooperate whatever, at least no.
Today, the glaring facts are that in 2 days in your account, there are 319
Yes, I have said.
debit entries,
and an
22
affidavit.
credit entries.
Yes.
Almost 7 crore rupees
7
coming to
crore.
your account and
No,
going.
live-
And under most suspicious circumstances, your phone disappears, reappears.
So, my lord, this is how
This is how crime operates.
operates.
Yes, organized crime operates like that.
So someone, my lord, who is not involved can also get into this.
Absolutely, we do not discount that fact. But what we say is, just because someone is honest and may be in the cloud of suspicion, we interfere with police work.
If they find
My lord, I
then-
need to provide
How do you
everything, all cooperation. My lord can
You are not inclined to entertain the recommendation of Article 32 of the Constitution. The petitioner commercial advice may submit comprehensive presentations to to multiple investigating agencies for their consideration of the material so to be relied upon before us.
Very well, man. It's great.
My lords, from item 36, some matters have been added presumably on the basis of the dispute between jurisdictional assessing
So most
officer
of the
and.
cases are covered by our
But
first
we
court.
need to verify all of them are not covered.
37, 45 have nothing to do with that Jalfao controversy. 37, 45, because there are other matters also I've been told. A lot of these matters have nothing.
There are two orders.
Yes.
We have passed two orders.
Please, Manoj.
Yes,
One is the original order.
Then the
The other is of
15, 16.
2015, 16.
Please, Manoj.
So some matters will be covered by the second order.
Because there are a lot of matters which will not be covered
Covered
by
by
either.
They'll have to be verified.
Either order. May I just point out? May I just.
Thing.
Arising on different issues have been clubbed and put.
Yes, ma'am.
Absolutely.
Yes.
Which is going on, or that's
In-
another issue going on.
In fact, Manoj, there is.
Issue of doubt, another matter on it. One is where 148 reopening on reasoning, that is going on. So all have been clubbed. What we understand, your lordship, today matter has been picked only to look into those who are covered by the your lordship judgment of 10.
So according to you, give us the list of those which are to go back to the High Court.
We'll do.
No, it has to be it has to be decided by this court only.
No, nothing to be decided by this court. Will
May I just point out, Manoj, if Manoj.
My lords, the orders will,
the
the
item.
appeals will have to be segregated into different groups, my lords.
Yes, they
because
will have to be
various
segregated,
issues
my-
are arising. My lords may give some time, we will segregate the groups. See,
But which are the matters which according to you are now liable to go back to the High Court in terms of our two orders?
Milord, I have about 8 matters, Milord, serial numbers 72, 73, 84, 85, 86, 87, 89 and
You
90.
will not like, you give a list of the matters.
I'll give
which
it.
are to go to
Only
the High
these
Court.
matters are that.
And in terms of which order? Out of
10th
the
April order. 10th April order.
mention that,
Yes.
you also give like this. And from your side also you.
Yes, yes.
Rest of the matters we will keep, let them do the grouping. huh?
Manoj, let
No,
them.
some of them are not at all concerned with this issue.
Matter, listed as serial number so and so, being covered by our order dated so and so, passing civil appeal so and so, or the order dated so and so in appeal so and so, are accordingly disposed of in terms of the above stated order and after setting aside the influence judgments, the matters are remitted to the High Court in terms of to be decided as per these orders.
Yeah, in terms of that, in terms of
Alex,
that.
we'll also give the list of matters which are to be.
Rest of the matters may like, keep it.
Matters which are to be kept.
The
Can I, my lord, just flag?
for the revenue will segregate the matters in different groups. And submit a detailed report with advance copy to land council for the SSCs.
I'm so great. My lords, can I just one issue, my lords? There are.
Number 51, it is covered by my lord's judgment.
54. Which are covered by this what we are saying. You please give on a piece of paper.
There are some matters which are not at all connected to this patch, my lord, that your lordships may put it in the regular.
Those matters you will only tell us.
I will tell it now, my lord. I will tell the matters which are not at all connected to this.
Just
81.5 and 81.3 are also, my lord, not covered by the order.
serial number 285, I'm seeking. Can, just on that, my lords, what my friend has just.
Piece of paper. If it is covered, please give on a piece of paper. If it is covered by a particular out of the two orders, there are not several hundreds orders. There are only two orders. If it is covered by those orders, very fine. If it is not covered, matter ends. Then they will do the grouping and will take up on the next date of hearing.
I'm so great. Please, just one nuance, my lords.
79, I think 41 similar SLPs have been dismissed.
Give on a piece of paper. If it is covered, give us one piece. Otherwise, not covered, then we'll take up on the next date.
It is covered, your lords, but the problem is that the respondent therein is the advocate on behalf of this honorable soul. The facts are completely misunderstood in the whatever the notice.
We can't hear you. Take the mic and then tell us.
My lords, the facts are completely different on what the notice has been issued and on what basis the order has been issued. If the matter is remanded back to the. Please, my lords.
You want the matter to be remanded or?
No, your lords. I want my matter to be.
Then remain silent. We are only saying that those who find their matters are covered, they only give the slip to us.
Please, my lords.
Or you also give the slip.
Yes, yes.
My lords, in respect.
We'll also give the.
Rest of the matter, list on so and so date.
My lord, in respect of the numbers provided by the respondents, the private assessees, if the department has any objections on those, then we must have liberty to file an application.
It is your responsibility. You act before us. You tell us whether we have passed two orders in your matter. You find out which matter is covered under those orders and which is not covered.
Very well, my lord.
Just for clarity, my lords, the tax matters are up to 80, my lords. Your lordships have passed this order in all or only, my lords, 36 as such? Because, my lords, there are many matters, tax matters. Plus, the tax matters at item 60, my lords, up to 80, my lords, there are many matters. So this order which your lordships have passed is in respect of all up to 80, my lords?
No, no. Let your.
As in,
My matter is item 90, which involves a completely different issue.
So different issue we are adjourning.
That's, there are some ideas.
Different issue matters we are adjourning to enable them to put them in the different groups and then we will take up group wise.
This doesn't belong to that group at all. It's an standalone matter.
Somebody will have to hear that also.
Called out first, it cannot be considered to be part of this batch.
That's what we are saying, that let them segregate those matters or you can segregate. But the matter will have to be finished. You have to decide them.
Similar matters, SLP filed by departments have been dismissed.
That's not connected to this.
Your homework, sir, please don't ask us to do your clerical job. Item 101.
Yes, please, your lord.
They have approved the iPod committee.
Supervisory committee dated 9th of February. My only submission is that the procedure illustrated.
Take mic.
My apologies. The procedure illustrated in the 9th of February order of the supervisory committee is not being followed in elections in Telangana. We are only seeking an affidavit to be filed by the Bar Council of Telangana stating that the procedure specifically.
You have approached the high-powered.
We approached the high-powered committee.
We are passing order requesting the committee immediately to take up the matter and decide.
My lords, may I still keep my matter pending till.
No, that if your grievance is satisfied or if it's not, either way you have to change.
My lords may direct them to file an affidavit because we had approached the High Part Committee earlier.
High Power Committee will call for their comment because we are making a time on the High Power Committee requested to decide the matter at the earliest and approval within 2 weeks. 2 weeks.
Please.
It is that case
Seeking
where
a
the
passover in this.
original record was.
Divan is
submitted from the
leading us, Mr. Divan is.
MSMC.
Has anybody come? Because who has come?
2 officers have come.
2 officers have come, my lord, I am told, along with the original record.
Anyone
That
for this
MSMC.
Maharashtra
State Mining Corporation. That's it.
वो दिखाइए लेटर आपका ओरिजिनल.
But these are the people.
आपके पास होगा ना ओरिजिनल लेटर, वो दिखा दीजिए.
दो लेटर.
पहले तो इधर दिखाइए इन लोगों से. पहले तो आप देखें. हाँ देख लो इसमें क्या. अरे हमारे को नहीं उधर दिखाओ. आपको देखा. जिनको ग्रीवेंस से पहले तो वो देखें. फ्रेश मैसेज हो गया. Please, Mr. Diwan, please see. We have not seen it. They have just opened the record.
Let him explain it. I don't know.
Eh?
The officer will have to
Or
explain.
both of you can see because
Okay,
we know that both of you can't. You will not dispute.
Excuse me.
अगर कोई डिस्प्यूट है तो मन से करते हैं ना. हाँ नहीं तो डिस्पोज ऑफ दिस.
This is the transaction which was J1 on 14th of June. This is not there in the original.
रख दो ये रख.
Is there in the original? This was sent on email. Where it was sent on email, it's not there. Let's be clear. So what happened was, my lord, the letter was first sent through email, which did not have the 4 lines. Then it was sent a hard copy. Hard copy is received, original hard copy, which has those 4 lines, which is there in their record. In the application, I said I will change it. Then there are 2 follow-up letters where they processed it that all right, we are changing it from Godegaon to the other worship.
Original letter is there.
Original letter is.
Original है वो साहब को दिखाइए.
3 versions.
आप explain it, your lordship.
आपकी फाइल में जो ओरिजिनल लेटर है वो पहले साहब को दिखाइए.
Hard copy which was received.
No, what they see, I don't know, but I think it's best to hear it from him. But it seems from what my learned friend has said is that there are 2 letters which are, I mean, one he says by email and one in original. The one which is sent by email does not contain the para. And that same letter.
The same day which was sent, the original hard copy.
Same letter, physical version on the file.
Contains the para. Because email may not be, it all depends.
And my lord, thereafter,
letter.
Just have a look. I think they'll have to explain it, Balo. Let them put in a short affidavit, because otherwise.
And my lord, thereafter,
just on this point.
Before my lord, it was taken up. My lord, just I want to add one thing. Before it was taken up by the committee, there are 2 letters on record. My follow-up letter that I am shifting it to the other, and they approved it for the other. 2 letters on record. It was actually shifted.
It's very curious because the number is the same of the communication. One by email, which doesn't have that para, and one has it. I don't know.
Only thing is, Mr. Diwan,
yeah.
Because when official communication is, some official letter is received, there is always a date and stamp.
Both have it. Both have it. I just saw it.
Obviously.
I'm told it's at 683. Just see the 683 version.
क्या बोल रहे हैं? 683.
687, my lord, is the physical copy which was got received.
How can a company give two letters with the same number and one with an inserted para and one without it? To the same authority? And I'll make my submission on this. It's astonishing.
And which one did they consider? We don't know what is.
Correct.
He's 19 to 84.
Yeah.
This is 14th of June. Thereafter, 20th of June, much prior to the opening of the committee, 20th of June, I write a letter with reference to this 14th of June with regard to shifting of washery. That's also on record, my lord, must be on record. 20th of June 2024, where the subject is follow-up on request to operationalize Sasti washery instead of Gondegaon. Then, my lord, MSMC writes to me. This is on record, page 294 of the SLP, this letter of 20th of June, which reaffirmed the fact that 14th of June I had written for change of washery. And then, my lord, at page 296, my lord, may kindly see.
Release of Gondavan.
Correct. 296 on the paper book. Then MSMC with reference to my request for change is writing to me that you have a requested for change.
Dichotomy which comes out is on the same day an email communication in respect of the same subject matter does not have.
Well, I'll just give me a moment.
Before that, I want to show those two letters. Just follow up those two letters.
Forward your submission.
Grateful.
I'll just make a suggestion. I think this should be actually placed on record by the Maharashtra Minerals, etc. But let me make my submission. I'll just take a moment. Please take up page 95 of the paper book. Manoj, may I just request the court master to hand over the paper book, page 95. This is the typed copy. Now, let me just state the point. The first is, this is the communication of 14th June 2024, which your lordship relied upon at that earlier order, etc. It is styled as being from Hind Maha Mineral LLP to the Managing Director, Maharashtra State Mining Corporation Limited. Now, just see the context of the letter.
So, Mr. Diwan,
Yes.
that way the impression given to us was
Yes.
that the subsequent a letter, a fabricated letter, after adding one paragraph, has been relied upon in court proceeding. We issued notice of director to the High Court only because of this reason.
Correct, correct.
We would have agreed to that if it was not part of the record. It is a part of the government, of the corporation official record, maintained in the course of their business, having a date of receipt, stamp and everything.
Yes. So now what I am suggesting to the court is that this is a fabrication. Now let me indicate why. Please just take up page 95. It's out and out, because now my learned friend admits that he sends an email without the paragraph. Just imagine, he sends an email without the paragraph.
So you see, it happens in business. We must have sent a mail. Somebody will call in that, look here, you have not mentioned.
But he doesn't furnish this explanation.
Say, all right, I will.
Because just a minute. He does not say that I sent two communications.
Examining it in the light of your conduct also, that you don't say anything till the matter is heard in the High Court. Probably you relied during the course of argument and suddenly next day.
But just see.
Filed it and you never mentioned it before.
No, but just see page 95. Your lordship will just see page 95. It's out and out an interpolation. Just look at page 95. Please see, they request Maharashtra State Mining Corporation. Please see the opening letter, opening para. With respect to the subject cited above, we request your good self to kindly issue the below mentioned experience letter for participating in the tender.
Yes.
Now, this goes through. Now that offending paragraph has nothing to do, because please see, and then the last line is that this certificate is being issued.
That contention, but we see.
So they issued.
Why, despite the fact that High Court decided the matter at length, still sent the matter back to the High Court.
Gratefully,
Only on the premise and because of the contention that this letter is not a part of the record, it has been fabricated.
No, so
now a government agency is coming before us.
Yes, but what did they act on? See, this is very important. They issued a certificate. The certificate didn't have the offending paragraph.
It is not supposed to have that offending paragraph. It is their certificate. That offending paragraph is my request to them.
Because how can, if you are copying verbatim, what I am trying to suggest is...
Except that paragraph.
Be a ground for the Madhya Pradesh Corporation to reject their eligibility.
But the Madhya Pradesh Corporation did reject.
It has been issued to me.
The High Court has...
Madhya Pradesh rejected. Even after the second round, which your lordships, after your lordships remitted it back.
Had it been a case of producing a false document in the court proceedings, we were taking very seriously. And me and my brother were very concerned about it.
But have your lordships ever seen two letters bearing the same number, the same date, one with an extra paragraph? I mean, I ask, in my experience, you will amend the letter.
What will happen? Suppose, assuming we take your allegation to a logical conclusion that somebody in the Maharashtra Corporation was colluding.
No, I am not saying that. I am not suggesting that.
If otherwise, then how to doubt a government corporation?
No, I am not doubting them at all.
It is there in their record then.
Both are there. So
therefore, what we'll do? If suppose an official of the corporation is colluding, first thing he will do.
No, I am not saying colluding. That's not my allegation. I don't want to say that. Milords, I am not saying colluding. I am saying what has happened over here is that letter without this the email without the paragraph has gone. That's my first point which I am making. If that is the communication which bears the number, what was projected to this court was incorrect, that they had on the 14th of June 2024 already written to the Maharashtra Corporation. That's wrong. That was an incorrect projection. They never said there were two communications with this extra paragraph which was sent.
There were not There is only one actual communication.
They don't mention that in the High Court.
One was cryptic, the other one is self-explanatory. That's all.
No, but there's a whole paragraph inserted there asking for talking about excess capacity, which was the disqualifying factor. Please see why they slipped it in. They have slipped it in over here for the very reason, so as to create some sort of a cloud of uncertainty over here when there was no uncertainty. Oh, one version with the same number has a paragraph. Another version doesn't have a paragraph. But this is not credible at all. It's not credible at all. Just a second here. Page 289 of the paper book. Para 8. I say and submit that in order to put rest any doubt of controversy regarding the authenticity of the letter dated 14th June, a letter of 24th June bearing...
Unfortunately, your conduct before High Court also couldn't inspire confidence.
But what was my conduct? Well, my conduct before the High Court was there was an error which I made of one day, because that affidavit was prepared on the 25th of November and it was endorsed and notarized on the 26th. That's the only error.
In that case, the minimum thing your counsel could make was, you could go to the bench and tell. Say, suppose
we told the bench, we apologized.
For this court,
we
they
apologized
insisted on
to the bench.
25th it was done. Before this court, they insisted time and again. I disputed it, but they said, no, 25th we filed. They are on affidavit.
See my review petition.
We are not initiating perjury proceedings. Otherwise,
well, what perjury proceedings? Well, someone files an affidavit.
Eventually, it is only a competition between two contenders. If the state get better revenue between you can still auction between you people and...
LOI has been issued to me. But I was L1, LOI has been issued to me.
Well, just see my review petition.
LOI has been issued to me now. They have already executed.
Just go to page 329. 329. I have explained it in my review petition. Just have a look at that.
That we have seen. We
Sorry?
are not,
because of that, we will
also really persuaded to go into the issue on that point. We have understood your explanation with regard to 25th, 26th. You brought up a more pertinent issue with regard to the nature of the communication. What we see, Mr. Diwan, is not a clear-cut case of an incorrect document being furnished here. There may be some doubts with regard to
Your lordship's experience is much wider than mine. I have never seen a company sending a letter under the exact same number and with a paragraph inserted, and then not disclosing it to the High Court, not disclosing it to the Supreme Court at any point, and orally making a submission that the owner of the company now understood it. I can understand if this was your explanation.
I understand that this is against normal human conduct.
I agree, but then it's for your...
But the problem lies elsewhere.
Yeah.
What is actually going through our mind is, had this document not been there, the other hard copy, it is clearly what you demonstrate before us.
Absolutely.
That there is a double standard. A email account containing a letter without the vital paragraph and a document placed before us with the vital paragraph.
And unpardonable.
Now, with an independent agency to whom the communication is made, we find two documents.
Okay, fair.
Yes, one without the paragraph, one with the paragraph.
Okay.
We accept what you are saying, that this appears to be a bit unnatural. As to why one, now some explanation is coming from them, but this is not a clear case where we would love to go into a further intrusion.
All right, Manoj, I take that. Now, Manoj, may I just make one final request? Well, I don't believe paragraph 18 of the impugned judgment, which is making a comment on expressification.
We can look into it.
I think your lordship...
That point is well.
Because what, 25th, 26th in the morning, night,
maybe somewhere the honorable judges were a bit...
I agree, but we had mentioned it all.
But even we have no objection to that.
What happens, Mr. Diwan, is there is a sense of what we would say oversensitivity at times.
Possibly.
Because judges feel that they are looked into with some degree of skepticism.
All right, very well.
That they have overlooked a document which they ought to have seen. So that's why the judge may have made that.
Fair enough.
I think definitely.
Yes, I'd be grateful for that. I'm grateful.
Senior counsel for the parties. The original record produced by
No, it's all.
Maharashtra State
Let him pass this on.
Wanted expert. Mines Corporation Limited, MCMC, has also been produced. In the facts and circumstances of this case, we are not inclined to interfere with the main judgment of the High Court. However, the observations made by the High Court in the petition, in the order passed while dismissing the review petition, causing direct or indirect aspersion on the petitioner, are completely satisfied.
Satisfied, great. Yeah.
And the council, my lord.
Yeah.
Basically, it's
Petitioner and
the
council, yeah, both.
Including paragraph 18, is satisfied.
I'm great.
That's it.
Please.
Very good.
Watch out.
Original record has been returned.
Six.
Don't know me. Don't know me. Don't know me.
Please, my lords.
It's in the matter. Any urgency in handling it?
Mediation has failed. We tried our
You know,
best.
say, my lord, urgency, my lord, since we are
We
waiting.
are asking only urgency. I have a meeting, therefore.
No,
I'm,
my lords. No, my lords, we didn't say.
This can be taken up on another day, my lord.
follow.
This is that Ganeriwala family dispute.
Any other extraordinary urgent matter? Otherwise, पता नहीं कितने matter रखे।
Would your lordship consider, my lord, listing this after vacation?
And 12. This is that Waqf board matter. We will take up on some non-miscellaneous.
My lord, 118 is a fresh matter. 120 is a fresh matter, which came on Monday, but your lordship.
Just a minute, Mr. Chidambaram. 112, are you appearing in 112 also?
No.
112 we will list on a non-miscellaneous.
Interim order, I think, protection order.
What is this Azad Singh Kataria? 113. BNS and BNS, so Shah needs to sign it over.
Madam, 113.
115 is the Aravali matter. Where is the union's list or other list? We were expecting some subject domain experts list.
They are actually not close. They are covered by your lordship's earlier 9th May order. All that we are asking is, let our ECB process, no mining will start.
No, nothing is to be processed. In Aram.
That order, that processing of application be done, no mining will start. We are even undertaking also.
In Aravali, the issue is completely different. Here we have not permitted anything to happen.
No, in Aravali, 9th May order, your lordships have said, process the applications, but don't plant anything. My lords will see, you got please see the order. In our IN not saved, 92194.
You are?
Until further order.
Order of 9th May.
Until further order, all states in which Aravali is an extra situated don't take
Where is the Union of India? Where is it?
consider and process.
So there is no order of 9th May.
MC Mehta, I think.
हाँ ये तो order कब से मिला था आपको? मैं talk Mehta order probably.
MC Mehta.
No. MC Mehta order will not apply here. But why don't in the paper book properly order क्यों नहीं लगा कर रखते साहब? Where is the union in this matter?
I'm 113.
Say post this matter on so and so date. Union of India has not furnished the list of domain experts so far. The parties are permitted to suggest some names. The amicus will also find out such names. The no further adjournments, no further time shall be granted in this regard. I say postpone so and so date for constitution of the expert committee. Then say meanwhile the interveners, the parties, and other stakeholders are permitted to suggest some names. Unfortunately, Union of India has not given the has not suggested the names so far. Little more time is granted. No further opportunity shall be granted. Where are the names, Mr.
Circulated already, detailed note. I circulated a detailed note with all the names.
You have suggested some name. Where are the union's name?
They had sent it to me, those are also incorporated them. The union filed an affidavit saying that those names which are PC and the union also suggested names, those are also part of my. It's a consolidated note.
No. Have you exchanged the notes
With the union, Millets?
about the names?
Yes, Millets. The union, the CEC and I are ad item on the names, Millets. The union, the CEC and I are ad item on the names.
My lords, I'm being led by the learned ESG. My lords, may pass over the matter.
They filed an affidavit also to that extent.
I'm not passing over the matter.
They filed an affidavit also to that extent saying that they agree with the names suggested by the CEC and the MI.
We are granting 10 days time. Whatever names you want to suggest, it's fine. Otherwise, we'll constitute the committee.
They have filed an affidavit agreeing with the names suggested by the amicus and the.
No, they have not filed any affidavit.
Filed an affidavit.
My lords,
we will see your eyes, but MC method we will not follow yet. Mr. Jachima, you also suggest some names.
my lords, I have suggested the names and I have filed a list of names. 14 names I have suggested, my lords.
Where are those names? ये हमारा ऑफिस इतना पोर शो करता है. Find out इस रिकॉर्ड में कहाँ इनको करके मिस्टर चिमा ने करके उनको देखो. We will see. We'll take up on a short date.
Please, your lordship.
And the 17, there is a letter circulated.
Plus, I'll give us extra copy of those affidavits if they are not able to.
मैटर लगे होते हैं उनको पेपर बुक पूर्ण नहीं होती.
We'll do that.
There's a letter in 117.
Item 118 are those Shiv Sena matters. Item 118 are those Shiv Sena matters.
Yes.
They are fixed for final hearing. Would your lordships have it, my lord, whenever, my lord, it's earliest convenience?
We will list the date, then you are stop your people to go to media and make irresponsible statements.
We'll do that.
You seek date here and then you say Supreme Court is not deciding the case.
We'll do that.
We want to catch hold everyone. We are issuing a warning. Be careful on using the words. I am not a person who will accept this kind of conduct. Here you don't want to argue, there you want to make a statement.
My lord, whenever your lordships fix, my lord, we will argue, my lord. There is no difficulty.
The argue today.
Yes.
When the matter is taken up, you say fix a date. When we fix the date, you say why these petty politicians are making statements then?
Lord, the matter was shown today in the list for directions. Yes, my lord. Matter was shown for the list for directions. My lord.
Court, they have no right to make any statement.
Your lordships are absolutely right, my lord.
We expect cooperation from both sides.
Yes.
And we are not sitting. Mr. Devdutt, you know that yesterday.
Yes, Lord, we have no difficulty, my lord. Whenever your lordships have a couple of hours time, my lord, lordships may fix that so that, my lord, we can finish it from our side and then my mothernet friends on the other side can, my lord, if it's possible, this side of the way.
Next date you can start. Meanwhile, the others can join.
Yes, my lord. Yes, my lord.
All right, we'll fix it now. Now it will go in July only.
Yes, my lord. Whenever your lordships have some free time, my lord, of 2 hours for each side, my lord, we can finish it off in a day, my lord.
Once your matter will start, then obviously all other matters will have to be adjusted.
Yes, my lord. Yes, my lord.
It's only a question of beginning. On the next date, then please be ready.
Yes, my lord. In fact, my lord, there is no problem at all from our side. My lord. We are actually anxious, my lord, because for 3 years, my lord, we have been waiting. Whenever your lordship fix the date, my lord, we'll argue it out.
We'll notify the date after seeing just देखो उसमें जुलाई में date बनता है.
Milord, your lordship may put it in the last week of July, milord. Things will be clearer. Then it can be heard, milord, on any Wednesday.
Yes, that we will do. We'll fix a date.
Yes, milord.
Our only concern is that whatever delay has been happened before at any stage of hearing, these irresponsible statements are being made, Mr. Rohtak. That is not something.
No, milord, I have been hearing that, milord. Our side hasn't done it. But anyway, milord, it should not be made by any side. We know the pressure upon the court. Your lordships are more than kind in hearing everybody. It's completely unacceptable. Milord, I join.
Also, we are sitting till 4 o'clock. If somebody find us sitting idle, we understand.
No, no, milord, there is no question. Your lordships are.
Lord, my lord, from our side also, my lord, as lawyers, my lord, we have absolutely.
As lawyers, milord, we will never support.
At all, my lord.
We will never support such a statement made by any party.
Because we know that all the matters can't be heard on one date, so we keep on adjusting so that at least your time and our time is understood.
No, no, milord, there is no doubt the court has been very patient and kind to everybody. No litigant has the right to say it on whichever side it may be, milord.
Mr. Rohtak, on 30th July, then we are fixing.
Yes, milord, certainly, milord, certainly.
30th July.
Very grateful.
Grateful. Grateful.
Okay, thank you. Item 125, what is the urgency?
119.
Election of Bar
20 is the one.
Bar Council election हो गया.
125.
So Bar Council election is over now. Bar Association election, we are told that today election is taking place.
We have come to my lords with a very high. I denied polling my casting my vote. Because my lords, the elections are being held in violation of the orders of this honorable court, as well as in violation of principle of one bar, one vote. And it's nowhere in the state.
That we will permit you to challenge it before the election tribunal.
But we all
No, we will not. It is not appropriate.
successful election petitions happen because the term expires and the turn never comes. So my lords, in fact, my lords may kindly at least stay in the counting of votes.
No, we will not say anything because.
My lords, otherwise, my lords, there is no one. We have
No, Bar Council will notify an election tribunal. We will send you there.
date of.
Is it not Bar Council election at all, sir? It is Bar Association.
My lords had given us the hope that if elections are held, we will set aside the election and fresh elections will be held. My lords, we have not.
If the women don't get it, that we will see after the elections are over, the competition is there. It's all right, please. You see, those where you know that how we have been able to at least obtain some effective representation.
Since
So now that be happy and be prepared for the next elections to gain something more strength. So next year I will campaign for you after retirement. We have already done. If they don't comply with, we will see later on. We will see. We will see. Let the election be over and then we'll see. Item 119.
Yes, isn't it the same?
Co-accused has been already, notice has been issued by the co-accused, Your Lordship.
Give a soft copy to the amicus and.
Rather, the petitioner was named in the FIR, not any specific allegation was raised. Your Lordship, no, petitioner is not the beneficiary.
provided to the women advocates in what the petition shall be at liberty to approve the appropriate form. Item 120.
So this is a fresh matter. This is a fresh matter. Your lordships may take it up next week. It's not so.
We declined to entertain Mr. Rodgers.
No. There are 3 points.
Same point.
One you left open. There are 2 other grounds do not arise in Rodgers' case. It arises in my case. The 3.
That Mr. Chidambaram has not been argued before the High Court.
No, we have argued and the judgment deals with it. Your lordship only read the judgment in that.
Substantial compliance of the affidavit.
That is one point.
And the point
The other point is your lordship's order remanding the matter, asked the High Court to consider the question of limitation.
Limitation
He has
also-
not considered the question of limitation. It is covered by a judgment that you can't file the second affidavit. Lord, let me take it through.
At all, there is a second affidavit necessary.
Lord, there is a third point. Second point is limitation. The third point is the affidavit which is alleged to have been substantially in compliance does not mention the source of information. But in Mr. Rohatgi's case, your lordship mentioned there was a source of information. Neither complies with the Odisha High Court form, nor does it comply with Form 25.
For technicality, we have already.
It's covered by a judgment in Bapat. You must have a source of information is obliged to be disclosed. Your lordship may give me 5 minutes. I'll take your lordship through the 3 grounds.
Chidambaram.
Yes, I'll argue. Now, kindly see, my lord, the act. Kindly see the 2 provisions. Your lordship did not have an opportunity to read the text of the 2 provisions. Kindly see section 83 of the RP Act. Kindly give the RP Act, Representation of People Act. No. Kindly see section 83, the language of section 83. Kindly see, this is at page 84 or so. 83 1C is the first. Kindly see section 83, Miller. My lords have section 83.
83.
Yes, 83 1C and then the proviso. An election petition 1C shall be signed by the petitioner and verified in the manner laid down in the Code of Civil Procedure for the verification of pleadings. This has to be read with the Odisha High Court rules and the form. The second one, provided that where the petitioner alleges any corrupt practice, the petitioner shall also be accompanied by an affidavit in the prescribed form in support. So the first one, 83 1C, the Form 25, the Odisha High Court rules prescribe an affidavit. This is also be accompanied by an affidavit. There are 2 affidavits, Miller. The text of the language says, kindly see Order 6, Rule 15. Order 6, Rule 15 requires an affidavit, and the Odisha High Court rules prescribe an affidavit. The proviso says also an affidavit, and that is in Form 25, is an affidavit. So 2 affidavits are required, 2 different forms. Kindly see Order 6, Rule 15.
So what is the ultimate contention? What is the ultimate argument?
Ultimate argument is there are 2 affidavits, 2 forms in 2 different forms. One prescribed by the Odisha High Court, one prescribed by the RP Act, Conduct of Election Rules. There are 2 affidavits. Here, the first affidavit is held to be in substantial compliance. I'll deal with that. The second affidavit is not in compliance with anything. Even the first affidavit is not in compliance with either the Odisha High Court rules or the Form 25. Two forms, two affidavits.
The hyper-technicality of affidavit.
No, no.
Let
Two
us
affidavit. My lord,
see how the High Court had dealt with. Where is the High Court? Paper book though.
There are two other points in your lordship's order reminding the matter. Your lordship directed them to discuss both points. Kindly see your lordship's order.
Yes, that would be just seen.
Kindly see the order at page 411 of the paper book. Paper 411 of the paper book. Paragraph 5. During the course of hearing, 411, my lord. My Lord Justice Bakshi has got 411. During the course of hearing, we find that one of the issues that arises for consideration is whether the affidavit
Already 11 and 12.
411, paragraph 5. During the course of hearing, we find that one of the issues that arises for consideration is whether the affidavit subsequently filed by Respondent 1, purportedly in Form 25, satisfies the requirements, and if so, this is the second question, whether such affidavit could be permitted to be filed beyond the period of limitation. This is covered by your lordship's judgment that it has to be filed within the period of limitation. The High Court says that the question of limitation does not arise in this case. Your lordship asked him to decide because the subsequent affidavit was filed 6 months later.
Page 38, paragraph 38 onwards.
Beg your pardon?
Paragraph 38 onwards, page
Yes.
25 of the impugned order.
Yes.
Please come to that.
No, no, I'll come to that. Page 27. Page 27.
25, sir.
Yes. 25. All right.
Yes.
I'll read 25.
This is the issue decision. So please indicate.
Page
once-
25.
Yes.
Coming to issues number 3 and 4, Mr. Samal would argue that the election petitioner filed Form 25, which is 166 days after filing the election petition. Since there is no provision in the RP Act to extend the period of limitation, said affidavit cannot be accepted. Per contra would argue that the doctrine of curability, as referred to by the Constitution Bank, is squarely applicable. He cites several cases. All those cases are cited. The requirement being procedural in nature, any omission in respect. Mr. Mishra submits that once the court holds there is substantial compliance with the requirements of law, the defect of any can be cured. Once cured, the same shall relate back. This court has in the preceding paragraph held that the affidavit on record substantially complies with the requirement of 25, and the defects pointed out therein can always be cured by filing a supplementary affidavit. The RP Act prescribes a limitation of 45 days. There is no provision to extend the period of limitation. The question is whether the period of limitation having since expired, the election petitioner can be permitted to file a supplementary affidavit. This is covered by a judgment of your lordship. This is covered by a judgment of your lordship. I'll show that judgment. In the instant case, it is not disputed that such an affidavit, which is 166 days, but then this court, having already held the defect in the accompanying affidavit, the election petition as a curable one, curable by a subsequent affidavit, it entails a rectification of the defect by filing a supplementary affidavit. In other words, the defect is one of form and not on substance. Had it been a defect of substance, it would have rendered the defect incurable. It would not have been permissible, but the defect in the instant case is one of the form, and therefore it's curable. Therefore, the Limitation Act would not apply. This is covered by a judgment of your lordship in 1995, Volume 5, Supreme Court Cases 347. I've filed a compilation of judgments. Page 197. This is the second point, and there is a third point about sources of information.
Sources judgment.
Limitation.
Limitation will be the first judgment.
I'm sorry, Miller. I cited the first judgment, Hukum Narayan Yadav versus Lalit Mishra. Limitation Act does not, Section 5 of the Limitation Act does not apply.
Page 20, paragraph 25.
But then that issue is not falling, Mr.
Pardon?
Nobody is seeking condemnation. The issue is, let us say.
He says it's curable. I'm filing now to cure the defect. He's filing it beyond limitation. There are judgments which say you can cure it if it's possible. It's possible to cure it only within limitation. Both judgments I'll show. First, the first judgment at item 2, paragraph 25. This is at page
20, page 20.
Page 20, running page of the compilation. Page 20, paragraph 20.
Hukamdev Narayan Yadav matter.
Yes.
Know that judgment very well, but that is not applicable here.
Just one line. For all these reasons, we have come to the conclusion that provisions of Section 5 do not govern. Then kindly see the next judgment, page 21 at paragraph 28.
Page 49.
It's at page 49. This is 3 learned judges, and at paragraph 28, kindly see the last line. They have given 4 grounds. The defect in the affidavit, this is according to me, it's an incurable defect, but according to the High Court, it's a curable defect. Let's assume so. The defect in the affidavit in the prescribed form 25 can be cured unless the affidavit forms an integral part of the petition, in which case the defect concerning material facts will have to be dealt with subject to limitation.
The affidavit that is disclosing material facts. Material facts are already there. He is only verifying person knowledge.
Well, kindly see section 83. Contents of the petition include the 2 affidavits. The contents of the petition include the 2 affidavits. Kindly see the marginal note of 83. Contents of petition. An election petition shall, provided that shall also be.
Material fact.
The affidavit is a part of the contents of the petition.
And the sources not being disclosed. That's very important.
1,000 days, my lord. He has to cure it.
Curability.
Abhi-
What nature of curability in the facts of FS Sapa, what was being cured is the averments pertaining to material facts which were introduced subsequent to
The material fact has to be supported by an affidavit. That affidavit is part of the contents of the petition.
what was in the facts of that case. Amendment actually went to the root of the pleading itself. That is material facts and not particulars. There the court holds material facts are independent of particulars. You can bring in particulars at any point of time, but not material facts.
This is neither material fact nor particulars. This is an affidavit affirming that the material fact is alleged.
So, sir, the amendment to the affidavit is not in isolation. Amendment in this relation to the introduction of the material facts by way of an amendment.
But I ask myself, can he file the subsequent affidavit 1,000 days later?
If the subsequent affidavit does not introduce a new material fact,
I'll come to the third ground. Both affidavits have to disclose the source of information.
We
Your Lordship,
fully agree with you.
now,
The
finding
there you are absolutely right, and we would have set aside this order had it not been this expression corroborated. And we may say that if when the evidence comes on record, he cannot lead corroborative evidence. Only he has to lead.
Please see the finding of the High Court.
Please come to page 21. Please come to page 21, the affidavit, and read with us III.
21.
21 is the affidavit set out?
This is the affidavit.
Yes, it is
He has
set out.
not disclosed the source of information.
Come to, sir. 111.
Roman 3, that the statement made in paragraph 6, etc., are based on my personal knowledge and corroborated by information received by me, and I believe the same to be true.
So-
He has not disclosed it.
Correct. So we will ignore the corroborative portion of the averment. Still then, the affidavit holds with regard to personal knowledge. And agree with you, if it had not been the word corroborated, your case was absolutely correct.
Your Lordship may permit me to show two other matters. First, page 23. Third, page 23 of the judgment, third line. Further, the sources of information has also not been specified
We agree.
in either affidavit. Either affidavit.
Absolutely correct, sir.
Now kindly see the judgment of your Lordships in Gajanan Bapat, 197 of the 197 of the compilation. Kindly see 197 of the compilation, paragraph 18. Your Lordships have in fact emphasized these words by putting it in italics. Kindly see 197, the judgment at
Mr. Chidambaram,
212.
will you agree with us if we observe that the affidavit is confined only to the personal knowledge, and that will restrict the petitioner when the evidence comes on board with regard
If your
to
Lordships
reading of evidence to prove.
If your Lordships come to the conclusion after reading paragraph 18, I have to bow down to it.
Page 212.
Page 212 of this judgment in Gajanan. Kindly see paragraph 18. A petition leveling a 212. That's a short paragraph, my lord, 4 lines. A petition leveling a charge of corrupt practice is required by law to be supported by an affidavit, and the election petitioner is also obliged to disclose a source of information. This is emphasized by your Lordship in italics.
Done by personal knowledge.
We agree with you. We are now deciding an issue of demurrer. And when we decide the issue of demurrer, what is at the back of our mind is access to justice. In
Well,
this
I ask
situation,
myself,
if the person says, ABC are correct practice. It is true to my knowledge and corroborated by information which he does not disclose.
He says so. He says so.
If that is the disclosure in the affidavit, we may bind him only to personal knowledge and restrict him not to lead evidence which is unspecified in the affidavit, because that may lead to, as held in Gajanan, a fishing and roving inquiry before the court adjudicating.
Please see paragraph 25. Please see paragraph, form 25 at 304 of this book. The Orissa High Court rules also oblige him to disclose the information. Form 25, which is allegedly the curing affidavit. We'll assume that it's a curing affidavit.
On that, Mr. Rodriguez also, we have not been.
Kindly see form 25, Miller.
Let us clarify.
Next, the two are true to my information. And the lordships have said, if he says, where is form 25? His form 151. Kindly compare the form in which he has filed the affidavit, subsequent affidavit.
I think we have had enough. We don't think that.
No, just one more minute, Miller. Form 25.
Yeah, that's the problem with every returned candidate. Nobody wants election petition to proceed.
I beg pardon, Miller?
That's a problem with every returned candidate. Nobody wants the election petition to proceed.
No. This is a highly technical matter. The people have elected me, and some voter or some petitioner wants to set aside the election. Your lordships have always held this is highly technical. If a single compliance is not there, it'll be discussed. It'll be dismissed. Now, he has not disclosed the source of information either in the first affidavit as required by the Orissa High Court rules, as required by Form 25. He has not disclosed any source of information. This is the distinction between my case and Mr. Rohatgi's case. My Lord Justice Bakshi said, I heard him say that in Mr. Rohatgi's case, there is no source at all. There is no source at all. Can he now another affidavit pleading the source of information?
Even if we ignore the source, he pleads it true to his knowledge. Should we non-suit him on that?
No.
At least give him the opportunity to lead evidence which is true to his knowledge.
No. Only he can plead evidence. He can depose. No other witness can depose.
That is not, but that cannot be a ground to prejudge the maintainability.
No. If your lordships are interpreting that way, please observe that he can't produce any evidence of a witness who is a source of information.
If he produces one, then that bridge will be crossed.
No. I can challenge it only after the trial is over. No. Lord, I have shown judgments which say Limitation Act does not apply. You can cure it within limitation, and you have to file a source. Your lordship may observe at least that
High Court is conscious of respect. That's why the High Court has.
No. High Court has said limitation does not apply. High Court has said that one affidavit is sufficient. High Court is completely wrong in my respectful submission.
Thank you, Mr. Chidambaram. Now we have spent enough time. We don't find any ground.
No, he is not really not clarified.
Item 122.
122, Malas. There are 3 issues, 3 points. There are 3 points, Malas. The first is, just note, Malas, they ask me to do prospecting on Malas 19/12/2005. And that is at page 588. Don't go to it, just note that. I do prospecting, and then they ask me for a geological report on 23/2/2012 at page 657. Malas, I write to them saying my prospecting and my geological report has discovered granite. Give me the granite for a reduced area. They, Malas, second time again say, give me more material for granite. I give them. everything is hunky-dory. In the High Court, suddenly for the first time, a supplementary affidavit is filed where they say that you have not asked for granite in Form A. And that new ground, never before, not by the authority who's got my application pending, not in the correspondence, is used to dismiss by. That's point one. Now, there's no question of A because granite is governed by the granite rules of 99. And there is no Form A there. Just see those three things.
No, Dr. Singhvi, from 2015, it is governed by the MMRD Act.
No, granite rules are under the Act. Granite rules will govern, not Form A. Form A is Jharkhand mining rules. Whereas granite, which I'm asking for, is under granite rules. Now see those 3 pages, but just see those 3 pages. First turn to Balas, page 658.
But if you go by the Jharkhand mineral rules, then after 2016,
Yeah.
you have no right to get a
Balas,
without an auction.
This ground of granite rule, this ground of Form A.
Hold anything against auction.
Therefore, Balas, just allow me to show the pages. This is
No,
too-
then so you fall in the director's reason that it is covered from 2016 and auction must be held.
No, Balas, in granite rules, if the prospecting, so you can dismiss
There is
the
no
ground.
prospecting license so far as the granite is concerned. It is with regard to magnite.
No, Balas, you can give, just allow me to show 3 pages. You can give me a granite license for a reduced area if the magnetite resources are scarce. Just see that now.
That scarce also is doubtful. Once in 2005, what happens? It
No, just see,
evaporates.
it's fine. You should not see any page. Just see the 3 pages.
137 I think, MT of granite in the first report.
Yes.
In the next report, it becomes, magnite in the first report, it becomes scarce in the second report.
Therefore, that's what he says.
Granite.
But I'm asking for a reduced area, Balas. So allow me to see the 3 pages, Balas. 658. 658. Please see 658. During the drilling of a borehole, the mineral granite is also being found obtained. We are providing the information to your good self. I write this. Then see, Balas. 662. I ask, I'll not read it, Balas. 662. I ask for reduced area from 147 acres to only 27 acres for granite. That's at page 662. Till now, nobody is mentioning Form A. Nobody. Now the reply is very important. 803. If this is right, suddenly in the High Court I am ambushed, then your 803 should have said so. With great respect, see 803, Balas. See 803. 803. In relation to the aforementioned subject and reference letters, it said that information for prospecting was provided. The applicant provided information about the discovery of a new mineral, granite. Please see the 803 is the single most important, Balas. There is them writing to me, mineral granite during prospecting in the licensed area. Rule 14 provides as follows. So this 14.5 is the relevant rule, no Form A. They are saying it. This is the point, Balas. They are saying, not me, the licensee shall report to the state government the discovery of the mineral not specified in the license within 60 days. Consequently, upon such reporting, such newly discovered mineral shall be deemed to have been included in the PL. That point is missed out completely. Then, Balas, please see, they acknowledge this, Balas. I asked for the reduced number in Balas, page 662. They acknowledge this.
That what you are saying, Dr. Singhvi, was possible before granite was incorporated into MMRD.
Now,
2015.
turn to 84.
MMRD Act,
right.
That deemed inclusion of granite in your prospective license of magnite will not go.
So just see page 84 and 85.
In both ways, either you fall because you don't go by the Jharkhand rules of Form A, and if you abandon Form A, then you fall on the ground that 2015 onwards, you did not have a prospective license for granite.
Can I answer those 2 points? I don't fall under granite rules. I don't fall because there's an exception under 10A2F. 10A2V. 10A2V says
to interpret the rule in favor of the
let me make it simple. My Lord Justice Bagchi is putting to me that if you go out of the Jharkhand rules, you come under granite rules, you fall there because of the 2015 amendment. Now, answer number 1. 2015 amendment has a saving clause. 10(2)A V says that if you have a ongoing prospective license, then you have a right to claim AML. See that section. that saves all the abolitions by the 2015 amendment. My lord is right. 2015 abolishes. Now see that section 10(2)(b). It says that if you have a PL, your right to ML is saved. Well, that section, that's directly answering Justice Bagchi's query. Now the second point after, first see that. Just see 10(8)(2), just see the act. Page 423. That's a very important query, and your lordship should not be under the impression that I am bypassing the act. Because that act nobody can bypass. 423. Just see the saving clause. I followed the saving clause. Well, 423 Chief Justice may have, page 423. Yes. 10A. Without all applications received prior to the commencement shall become ineligible. Right? Now the saving. Without prejudice to above, the following shall remain eligible on and from the commencement date. B. Where before the commencement of the MMDR Amendment Act, RP or PL has been granted in respect of any land for mineral. That's where I fall under. Now, this I've saved. Now the question arises, which law applies? 84, page 84. Now, if I'm saved here, as per Justice Bagchi's query, then 84 allows me under granite name, by name. Turn to 84.
Had they interpreted in your favor, we would have set aside it. In a minute.
Well, just see 84.
Yes, you have seen it.
84 is Granite Conservation and Development Rules 99. And under these rules, para 4 and 6 allow me to get it. There is no form A. Just see clause 4 and 6. 4 and 6. Now, kindly see. There is an act. The Amendment Act saves me. Then there's a by name granite rules. I'm talking of granite. See clause 4, para 4. Clause 4 at page 85 says, prospecting to precede mining operations. For granite, your lordship knows a specific item will cover and a general item will be excluded. Then rule 6, period for which these may be granted or renewed. Now, I only asked today, your lordship doesn't have a dismissal on merits, with great respect. The dismissal is that I did apply under A. So if your lordship finds, as I'm showing, that these rules in front of your lordships have no A, they have no A, they have 4 and 6. It should be remanded for consideration under 4 and 6. Your lordship is not going to say whether that I'm entitled or not. They have not considered it, saying Form A applies. Where is Form A in granite? Well, there's none.
Sorry, Dr. Singh.
Deeply obliged.
Item 123. Yes, I do.
Please, your lordship. Lordship, this was filed against an interim order, merits.
In case is pending, the entire the preliminary examination has already taken place. So no relief can be granted in that regard. The petitioner, however, shall be at liberty to raise all the contentions in the main case. With liberty of ordinance and yourself to discuss. 124.
May I please?
Please go to High Court, apply for your impediment and for modification of the order.
Kindly appreciate, the matter is posted after vacation.
So
More than a month, the operation is not happening.
Absolutely.
A huge financial loss for the person.
It has been a huge illegal financial gain for
I
you.
am not a party before the High Court, madam.
Go and become party. That's the reason we are permitting you.
The prayer only is
You are a party to illegal mining. Now go and clear your name before the High Court.
Kindly appreciate, my lord. The prayer itself was only against one single party.
Mr. Counsel,
My
the
lord.
first thing is you have not annexed the report on the basis of which the High Court passed the
I am not
order.
a party.
So go and get that report before you file an SLP.
May further seek modification of the entire order. It is clarified that we have not expressed any opinion on merits.
Lord, can I just mention item number 40?
Yes.
Lord, I'm just seeking some time to file my rejoinder.
Yes, granted.
I'm so grateful.